Good morning and welcome to the Subcommittee on Telecommunications and Finance. Today, the subcommittee is holding an oversight hearing to examine the problems of unscrupulous rogue brokers in the securities industry. This hearing will focus on how the securities industry and the regulators identify and discipline stockbrokers who engage in abusive sales practices. We will be asking what steps are taken to better protect investors against abusive sales practices, and what is being done to ensure the removal from the industry of truly bad apples who commit serious violations of the rules or repeatedly abuse their customers. The vast majority of stockbrokers are honest and ethical professionals who work hard, live by the rules, and do their best to serve the investment needs of their customers. Unfortunately, it takes only a relatively small number of individuals or firms willing to abuse the public trust for private gain to undercut investor confidence in the fairness and the integrity of our securities markets. Clearly, stockbrokers who view the public not as customers to be served but as sheep to be shorn have no place in the industry. Our system of broker-dealer sales practices regulation is based on the concept of securities industry self-regulation, supplemented by SEC and state regulatory oversight. For such self-regulation to work, however, three things are necessary. First, securities firms must establish, maintain, and enforce strong internal controls and exercise effective supervision over the activities of their employees. Second, the securities industry self-regulatory organizations, principally the New York Stock Exchange and the National Association of Securities Dealers, must vigorously examine member firms for compliance with their rules and with the federal securities laws and discipline those who engage in abusive sales practices. And finally, the SEC and state securities regulators must exercise aggressive oversight over the system and be prepared to initiate their own enforcement actions when there is evidence of violations. Over the last few years, disturbing questions have been raised about the operation of the existing system of the securities industry self-regulation system. The SEC reports that, quote, concerns regarding the hiring, retention, and supervisory practices of large broker-dealers increased as a result of commission examination findings in 1991 and 1992. Public attention began to focus on shortcomings in the system following press reports suggesting that many unscrupulous rogue brokers have been able to remain in the industry even after amassing significant records of disciplinary actions, customer complaints, and arbitrations against them. In response to these concerns, in July of 1992, the SEC initiated a wide-ranging inquiry into the hiring, retention, and supervisory practices of the 9 largest broker-dealers, which collectively have approximately 49% of all public customer accounts in the United States. Separately, the General Accounting Office, at the subcommittee's request, undertook an inquiry into the problems raised by unscrupulous stockbrokers. The subcommittee will be examining the findings and the recommendations in the SEC and GAO reports that disciplinary surveillance systems be improved to allow better monitoring of rogue brokers and to impose sterner disciplinary sanctions on those found culpable for sales practice abuses. I look forward to the testimony of the witnesses of both distinguished subcommittee panels who are going to grace our subcommittee here today. And with that, I want to turn and recognize the ranking minority member, the gentleman from Texas, Mr. Fields, for an opening statement.
Thank you, Mr. Chairman. Today, we review the recommendations of two reports produced by the Securities and Exchange Commission and the General Accounting Office. These reports conclude that even a few unscrupulous brokers can cause serious financial harm to investors and have the potential to damage public confidence in the securities industry. And no one can argue with those particular conclusions. SEC examinations confirm there are some salespeople among the 500,000 in the securities industry who should be the subject of closer monitoring. That's not news. Firms who employ people who have generated customer complaints or who have a disciplinary history understand that Congress insists that these salespeople be monitored closely. The securities industry, the capital raising mechanism for the American economy, has never challenged that obligation. Indeed, the firms of the securities industry are working with the SEC, the New York Stock Exchange, and the National Association of Securities Dealers to ensure that firm compliance and registration systems identify potential problems and monitor the activities of the sales force. Similarly, self-regulatory initiatives like updating the industry's central registration depository, known by the initial CRD, represent an expenditure by the industry of millions of dollars to improve the collection and recording of disciplinary actions instituted against its own sales force. In this manner, an industry effort allows the state and federal regulators to better meet their responsibilities. These are not the actions of an industry that would condone rogue brokers. After carefully considering the results of the SEC examinations and the additional analysis of those results by the GAO, I find myself questioning whether a rogue broker problem exists at all. And that's not to say that there are individuals who themselves are problems. I see nothing in these reports that indicates an epidemic of rogue brokers plundering their clients' accounts and moving on with impunity to the next broker-dealer. I see nothing that indicates an industry-wide problem of securities firms hiring problem brokers after turning a blind eye to their disciplinary histories. The securities industry employs 470,000 registered representatives. Of these, the GAO report concludes that approximately 9,800 had at least one disciplinary action against them. In fact, that number includes any adjudicated matter before court and may not involve the securities laws. Convictions for driving while intoxicated or an adjudication of personal bankruptcy or a lien on a personal account are examples of, in the words of the SEC, those types of actions that arguably do not affect an individual's ability to act in a fiduciary capacity as a broker. And I'm in agreement with the SEC conclusion concerning the GAO report that in light of these factors, I believe that care should be exercised in drawing conclusions based on GAO's universe or their sample. But even if we took the GAO's worst case analysis, if there were 9,800 brokers with a single disciplinary action in their background, and we said these were, in the words of the GAO, the unscrupulous brokers, that would be 2% of the total broker population. 98% by definition would be scrupulous. If the 816 brokers GAO identified as having 3 or more disciplinary actions are the unscrupulous brokers, that is 0.2% of the total number of brokers, which means that over 99% would be, by definition, scrupulous. And we all agree that even one rogue broker is too many. But I think we have to be realistic. Frauds and sales practice violations are often difficult, if not impossible, to stop before they happen. The system of broker regulation that has developed over the years is to identify those who violate the rules and then throw the book at those particular people. By making an example of those people, others who might consider breaking the rules are discouraged from doing so. That system is apparently working in the securities industry to the extent that even in the worst case analysis provided by GAO, 98% of all brokers are not a cause for concern. And this is not an attempt to minimize the importance of the securities industry maintaining systems to monitor the sales activities of its employees and to maintain systems to examine the disciplinary histories of potential employees. Nor is it a statement of insensitivity to those who lose money as a result of the unethical or illegal action of some stockbrokers. It's appropriate to question, however, what glaring inadequacy has been identified in either the SEC or the GAO reports that would justify making customer complaint information generally available to the public. Customer complaints of fraud may be based, in fact, only on customer dissatisfaction when an investment goes sour. The disclosure of customer complaints, unproven and perhaps never the subject of disciplinary action of any kind, could seriously injure the business prospects of an individual trying to sell securities on a fiduciary basis. Regulators at the federal, state, and self-regulatory levels must do more than meet the statutory obligation of ensuring investor protection. Their regulatory mandate must be carried out within the constitutional restriction of protecting the rights of those accused of wrongdoing to due process of law. Consequently, when the SEC and GAO recommendations for expansion of the CRD database are examined, it is also our duty to ensure that only appropriate information is contained in the system and that it is treated with the confidentiality it deserves. Before the information in the CRD is expanded, there should be a correction of long-standing problems concerning the existing system. The most serious problems relate to the potentially unlimited disclosure of data in the CRD, including data on unsubstantiated allegations. Steps must be taken to ensure against the publication of information that will injure those unjustly accused or those who have not had an opportunity to defend themselves. The SEC and the GAO reports serve to increase industry incentives to develop and refine systems identifying problem brokers and monitoring their activities. To that extent, I support the agency efforts on behalf of the investors. Since the industry and its regulators are in agreement that problem brokers require special supervision, I'm confident that to the extent that any problem exists, we are a long way toward a resolution. And I look forward to the testimony today. I'm sure that it'll be enlightening. Thank you, Mr. Chairman.
Great. The gentleman's time has expired. The chair recognizes the gentleman from North Carolina, Mr. McMillan.
I thank the chair. I'll have to leave rather quickly to go here to another hearing on above-ground storage tanks, which seems to be petroleum tanks, which seems to be more on the minds of my constituents than rogue brokers. And so I'll have to miss some of the testimony this morning. And I recognize that there have been incidents that stand out as cause for alarm and are a logical subject of oversight of this committee. But if it were a pattern among securities brokers in the business today, I suspect the industry, which relies so much on public trust, would be the first to raise the red flag. Indeed, the broker-dealer community is based on a system of self-regulation subject to federal and state oversight. Brokerage firms, for the most part, maintain internal compliance systems for their own people. These same brokers are policed by the industry's self-regulatory organizations, the NASD, the stock exchanges, and the SEC has direct oversight over the activities of these broker-dealers, which, as do state securities regulators with whom they must all register. In the wake of press allegations of widespread abuse by such rogue brokers, the SEC undertook an investigation, as has been pointed out, of the 9 largest broker-dealers, representing almost half of the brokerage business done at the time. The result of their examination revealed that these press reports were vastly exaggerated. More than 1/3 of the brokers who had been subject to past disciplinary actions were no longer in the industry. Less than 6% of the cases examined involved big producers, and in most cases, problem brokers could make only one job change, firm change, before they were forced to leave the industry. I don't mean to imply that the SEC did not uncover problems. There's undoubtedly a need to beef up regular SEC examinations as well as internal compliance systems at some particular firms. As the GAO will recommend today, there needs to be more effective reporting of disciplinary actions in the industry-run central registration depository and a strengthening of existing disciplinary standards. I would only caution that this committee not overreact to this problem by imposing penalties without adequate due process for those brokers who might have been disciplined for non-fraud related matters. Requiring that customer complaint information be made available to the public, as the GAO suggests, strikes me as a dangerous overreaction to the problem that might produce unintended results. I hope to be able to return after some period to hear the rest of the testimony and thank the Chair and our witnesses and yield back the balance of my time.
Gentleman's time has expired. The Chair recognizes the ranking minority member on the full committee, the gentleman from California, Mr. Moorhead.
Thank you, Mr. Chairman. I certainly want to welcome the illustrious witnesses that we have this morning. This is an important subject because the few rogue dealers and brokers that we have cause great consternation among the good people in the industry, of which do constitute virtually all of the industry. But it also causes concern among potential buyers, people who are in the market, and they are concerned by that kind of behavior, and it drives some people out of the market. I think it's an important thing for us to look into and be as careful as we can that we do eliminate those brokers that cannot live up to the rules. I'm looking forward to the testimony today. I also have another hearing going on at the same time. It seems to happen so often. But I know your testimony will be very helpful to us, and we are very concerned about the subject. Thank you.
The gentleman's time has expired, and all time for opening statements by the members of the subcommittee has expired. We'll now turn to our first panel, which consists of two institutions that have done excellent work in this area, identifying the problems and making recommendations that I think will go a long way towards ensuring that investors are protected against rogue brokers. And we'll begin by hearing from the Honorable Arthur Levitt, who is the chairman of the Securities and Exchange Commission. We welcome you back whenever you're ready. Please begin.
Chairman Markey and members of the subcommittee, I'm grateful for this opportunity to testify on behalf of the Securities and Exchange Commission on a subject that is especially close to my heart: the SEC's efforts to raise the professional standards of the securities industry. This month, as we mark the 60th anniversary of the SEC, we also celebrate the unparalleled contributions of the securities industry to the economic well-being of the United States. In 1934, businesses raised $641 million in our capital markets. Last year, that figure broke the $1 trillion mark. This massive investment is fueling our current economic growth. Mutual funds have brought tens of millions of Americans into the market. In 1980, 1 out of 16 American households owned mutual funds. Today, it's 1 out of 4. For the first time in our history, investment company assets now rival the deposits of the entire banking system. This huge influx of new investors has really been great for America. And it's also given new meaning to the concept of investor protection. Mr. Chairman, as I have noted on a number of other occasions in my first year as chairman of the SEC, hardly a day has passed that hasn't reinforced my conviction that investor protection is the mandate, the goal, and the public trust that must be uppermost in my mind and in my actions. Whether dealing with the problems of the mutual fund industry, the activities of the nation's securities exchanges, or the misdeeds of those who prey upon the public, safeguarding the interests of America's investors is what guides our attitudes and guides our decisions. I regard all of our investor protection initiatives as extremely important, but of them all, there is one that resonates with a very personal meaning, and that is our work to raise the professional standards of this industry. For, as members of the committee know, I come out of the securities industry. I was a broker. I was a supervisor. I know the pressures. I have benefited from the rewards. I'm extremely proud of the profession and the industry, I'm also realistic about their problems. Individual investors are seeking security and growth in the financial markets today as never before. Many are inexperienced and don't understand the markets. A stockbroker is their advisor, their guide through the maze-like world of finance. A broker's impact on a client's life can be every bit as profound as a lawyer's or an accountant's, or sometimes even a doctor's. That professional reputation must be preserved. But lately, I suspect that that reputation stands somewhat threatened. Public opinion surveys show that of all professionals, people have the least confidence in lawyers, lobbyists, and brokers. And this state of affairs hurts the profession, and it really hurts our markets. The poor practices of a very few have hurt the good reputation of the many. It's my goal to change that by raising professional standards and by running unethical brokers out of the industry. The first priority of the SEC is to protect individual investors. Consumer protection is our birthright, our focus, our mission, and really our passion. We take it personally when someone gets hurt by a bad broker, and we're going to do everything we can to help prevent it. For that reason, in 1992, the Commission, together with the New York Stock Exchange and the NASD, undertook a review of the hiring, retention, and supervisory practices of 9 of the country's largest retail brokerage firms. The results of this large firm project were released in May of this year. We selected 161 branch offices for examination. It wasn't a random sampling, but was based on their large numbers of customer complaints. 1/4 resulted in referrals to enforcement. This alone is significant evidence that sales practice abuses by brokers is something that continues to require our attention. We also examined registered representatives who had been the subject of sales practice complaints, litigation, or disciplinary actions. More than 1/3 had already left the securities industry by the time of our study. But of those still in the industry, the majority had been able to change jobs at least once, indicating some willingness among firms to hire individuals with a history of customer complaints. What do these findings tell us? Frankly, we were disturbed. We weren't at all surprised to find sales practice abuses. And we continue to believe, as you do, that even one bad broker is one too many. But although the problems we found were serious, they were not indicative, in our judgment, of a systemic breakdown. We found that some firms, obviously, were much better than others in minimizing bad practices, showing that the tone set at the top really can make a difference. It's our belief that many cases of investor fraud, if not most, constitute 2 essential failures: that of the broker and that of his or her supervisor. And therefore, in all cases where we do find bad practices, we've begun to ask the question, where are the supervisors? Did they ask the right questions? How did they let this happen? The project report made a number of recommendations which we've already begun to implement. We identified 4 areas that need improvement. One is enforcement. We're going to be tougher on sales practice abuses. That means more examinations and more expensive sanctions, which will raise the cost of bad practices. It also means keeping bad brokers out of the industry. And so I'm announcing that from this day forward, any broker applying to the SEC for re-entry into the industry after an unqualified bar for egregious misbehavior, that broker can expect the administrative equivalent of climbing Mount Everest before he gets back in. We only impose bars in these most serious cases, but when we do, then absent extraordinary circumstances, they're going to be permanent. Secondly, information. We need to develop better information about bad brokers. We expect to come forward with measures that will afford qualified immunity from defamation suits to firms that disclose in good faith the reasons why a broker has been terminated. We've asked the SROs to continue monitoring the timeliness of forms that help identify possible sales practice problems, to have their member firms report customer complaints quarterly, to review sales practice allegations made in arbitration cases when they're filed rather than completed, and to ensure the proper coordination and tracking of SRO investigations. Third, access to information. We're working to build a better central database to give firms, regulators, and the public easier access to broker disciplinary records. We've been working with the NASD to update its central registration depository. When completed in 1996, the CRD will enable regulators to search hundreds of thousands of records to identify problem brokers and target firms for examination. We've also asked the SROs to make investors more aware of the NASD's toll-free number for inquiries into a broker's disciplinary history. And fourth, supervision. Firms really need to take a harder look at a broker's disciplinary record before hiring. We're asking them to include their legal and compliance departments in decisions regarding the hiring of salespeople with a history of sales practice problems. And if a broker is hired against the recommendations of those departments, we want someone up the chain of command to put the decision in writing. We've also put firms on notice that if they do take the risk of hiring a broker with a bad record, they must be particularly vigilant in their supervision. The whole chain of command ought to be on red alert. I should add that independent of these recommendations, we're continuing to address the potential for abuse in sales practices such as cold calling. Thanks to the work of this committee, President Clinton has signed into law measures to protect consumers in connection with sales made with a telephone. And our staff is now considering a rule to curtail what is abusive cold calling. I'm also announcing today that the Commission, in coordination with the NASD, the NYSE, and the North American Securities Administrators Association, is planning a second joint examination sweep, with a large firm project focused on specific large firms. The second sweep will include small and medium-sized firms, and in the course of the next 6 to 8 months, we'll be visiting scores of branches throughout the country. To those who would prey on unsuspecting investors, this is a warning: clean up your act or we're going to do it for you. Mr. Chairman, I believe that the recommendations outlined in our report, together with our ongoing activities in policing the industry, will go a long way toward removing the tarnish on the profession. And I look forward to discussing all of our proposals and their status with you today. But as I noted at the outset, it's equally important to raise standards in the industry. And we've identified 2 ways to do this. One, enhancing education, and re-examining compensation. A broker, like a doctor or a lawyer, needs advanced training in his profession. In the financial industry, good training can make the difference between a sales force and a sales farce. Over the last few months, an industry group known as the Council on Continuing Education has been developing a curriculum that promises to improve practices throughout the industry. The premise of the program, once in place, is simple. A broker must participate or his registration will become inactive. I wholeheartedly endorse the mission of this council. Its members are developing a curriculum, and SRO rules have already been proposed for public comment. The aim is to have a system in place by July of 1995. I look forward to reviewing and to embracing their proposal. Broker compensation is a far more difficult and more complex issue. I'm concerned that some compensation practices may tend to exaggerate conflicts of interest. That is, encourage brokers in some cases to make trades rather than to do what's in the client's best interests. For example, is it appropriate for a firm to pay its sales force more for principal transactions than for agency transactions? Is it appropriate to differentiate compensation by product? Many worthy and creative ideas are already in place or under consideration. Some firms now offer a choice. When you open an account, you can pay by transaction, or you have the choice of paying an annual fee. Other firms pay brokers according to the assets under their management for the first 2 years rather than throwing them right out there on commission, sink or swim from day one. I'm also troubled by the use of contests that reward brokers for selling one product over another. It's hard to see how that may be in a client's best interest. From the time I entered the securities business to this very moment, my only standard has been that the interests of the customer must come before those of the broker, before those of the firm, and those of the industry. Sales contests, I believe, are an insult to that notion because they seek to put a broker's interests in a trip to Hawaii, for example, above the client's interests in the best investment. We don't pretend to have all the answers, but I do firmly believe that the public's view of the industry is inextricably linked to compensation practices. When a broker recommends a given security, the investor should never have to second-guess whether the investment is in his interests or whether the broker is simply trying to make a quick buck. I've asked a committee of industry leaders headed by Dan Tully, the chairman and CEO of Merrill Lynch, to examine the question of compensation and incentive practices. The committee has already issued an open letter to the industry and will also reach out to the public in an effort to address industry compensation practices, identify actual and perceived conflicts of interest, and describe the best practices in the industry. We'll be looking forward to hearing what they have to say. Mr. Chairman, I end where I began, and that is the American investor. From my first day as chairman of the SEC, I've made it clear that the consumer is our touchstone, the measure by which we appraise our every action, and the standard by which we judge our success or failure as an agency. Consumers must have faith in the integrity of the brokerage industry. I know that industry will work closely with us to see to it that their integrity is not compromised. And we're going to show no pity to the broker or firm that breaches that faith. We're going to work closely with industry leaders and with members of this committee to fulfill this mandate. Thank you.
Thank you, Mr. Chairman, very much. And now we'll turn to our second witness, Mr. James Bothwell, who is the Director of the Financial Institutions and Market Issues of the General Government Division of the General Accounting Office. The General Accounting Office, known as the GAO, is the branch of the government responsible for auditing how the various aspects of the federal government or even private sector areas that the government has an interest in are operating, and has the highest reputation of any branch of government. So we welcome you, Mr. Bothwell. Whenever you're ready, please begin.
Thank you very much, Mr. Chairman. Mr. Chairman and members of the committee, we are pleased to appear today to discuss the oversight and discipline of unscrupulous brokers by the Securities and Exchange Commission and the Securities Industry Self-Regulatory Organizations, or SROs. We are also issuing today the report we have prepared on this subject in response to your request and the request of Chairman Dingell. In my testimony today, I will briefly summarize our major conclusions and recommendations. These focus on three areas. One, the extent to which unscrupulous brokers are active in the securities industries today. Two, regulatory and industry efforts to discipline unscrupulous brokers. And three, the capability of the securities industry to identify unscrupulous brokers through its database on brokers' disciplinary histories. We share your concern, Mr. Chairman, that investors are not being sufficiently protected from the activities of unscrupulous brokers, so-called rogue brokers. Even a few unscrupulous brokers can cause serious financial harm to investors and have the potential to damage public confidence in the securities markets. We found that to better protect investors from unscrupulous brokers, surveillance, detection, and disciplinary practices need to be strengthened. Unscrupulous or rogue brokers can constitute a range of behaviors that can adversely impact investors. we defined unscrupulous brokers as brokers who commit a significant breach of sales practice rules or have a history of repeated sales practice violations. And in my prepared statement, Mr. Chairman, I go on to cite some of the common sales practice violations that occur. Brokers who engage in such activities are subject to various disciplinary actions, both formal and informal, by SEC, state regulators, SROs, the courts, and their employers. To address relatively minor violations, SROs can use informal actions. For example, they can issue the broker a letter of caution, which is a warning letter, or conduct a compliance conference, which is a conference between SRO staff, the firm, and the individual broker to arrive at corrective actions for the violation. To address more serious violations, formal disciplinary actions can be used. These include imposing monetary fines, censures, restitution orders, suspensions of varying lengths, and bars from certain or all securities-related functions. SEC, state regulators, and SROs can each impose such formal actions. Mr. Chairman, we could not determine the exact or complete extent to which unscrupulous brokers are active in the securities industry today. This is because, one, sales practice abuse is often very difficult to detect. Two, the Central Registration Depository, or the CRD system, which is an information system that maintains information on brokers, does not contain data on informal disciplinary actions. And three, the CRD is not designed to provide summary data by type of violation for the disciplinary histories it does maintain. However, we were able to obtain CRD data showing the number of active brokers with formal disciplinary histories. And I emphasize here formal histories. These formal histories include actions for securities-related violations, such as sales practice abuse, and non-securities-related offenses, such as drug possession and driving while intoxicated. Our analysis of this data indicated that about 10,000 of the almost 470,000 active brokers listed in the CRD as of November 30th, 1993, had at least one formal disciplinary action taken against them for a variety of violations, and 816 brokers had 3 or more formal actions taken against them. In our opinion, even a few unscrupulous brokers can cause serious financial harm to investors and have the potential to damage public confidence in the securities industry. Available evidence, however, points to shortcomings in the detection and discipline of unscrupulous brokers. State regulators responding to our survey viewed SEC and SRO actions as being too lenient. Of the 44 state regulators who responded to our survey, 14 believed that SEC disciplinary actions were too lenient, 24 viewed NASD actions as being too lenient, and 11 viewed NYSE, or New York Stock Exchange, actions as being too lenient. We found that certain disciplinary policies and practices could contribute to this perception. For example, we found that even so-called permanent bars, which are bars that prohibit brokers from working in the securities industry in any capacity for an unspecified time period, may not, in fact, permanently remove unscrupulous brokers from the industry. This is because the Securities Exchange Act of 1934, as amended, allows brokers barred by SEC or an SRO to return to the securities industry if SEC and the SRO approve such a return. Between October 1991 and December 1993, SEC permitted one permanently barred broker to return to the industry and approved employment changes for 5 permanently barred brokers whom the SEC had earlier approved for reentry. In its May 1994 study, SEC staff recognized the need to strengthen disciplinary safeguards and recommended to the Commission the use of truly permanent bars, that is, bars with no possibility of reentry to the industry. In our review of current laws and regulations that are intended to safeguard investors, we also found regulatory gaps that allow unscrupulous brokers to migrate to other sectors of the financial services industry. Currently, SEC and the Commodity Futures Trading Commission are authorized by law to honor each other's bars. That is, they can choose to prevent barred individuals from migrating between the securities and the futures markets. However, there is no similar law or agreements with SEC and other regulators. This creates an investor protection gap. An unscrupulous broker can migrate to work in an industry that is not federally regulated, such as the insurance industry, and sell certain financial products, such as annuities, in that industry. Similarly, such a broker can work as a bank employee in a federally insured bank, selling bank-sponsored mutual funds if he or she has a disciplinary action taken against them but has not been convicted of a crime. We found examples of migration in our sample of disciplined brokers and in our follow-up of potentially unscrupulous brokers that SEC identified in its recent staff study. SEC's recent study also found problems in the detection and discipline of unscrupulous brokers. In July 92, SEC initiated an examination of the employment and supervisory practices of 9 of the largest broker-dealers in the United States. On the basis of customer complaint information, SEC identified those branch offices and brokers most likely to have problems and reported that problems existed in the hiring and supervision of brokers at 25% of the 161 branch offices reviewed and made 40 referrals for potential enforcement action. The staff study made specific recommendations to improve the hiring, supervision, detection, and discipline of problem brokers. To safeguard investors and maintain public confidence in the nation's securities markets, SEC, state regulators, and SROs need effective broker surveillance and monitoring systems that can help them identify brokers who have engaged in questionable sales practices and sales practice abuse. The National Association of Securities Dealers and state regulators maintain CRD, which is the only centralized source of information on brokers' employment and disciplinary histories. Information in CRD is available to both regulators and investors and is now relied on as a regulatory surveillance tool. However, we found that CRD, which was originally designed as a broker registration system, has design limitations that weaken its capability to support regulatory surveillance of unscrupulous brokers. Also, CRD records only of formal disciplinary actions, not informal actions. Further, SROs are not required to report to CRD information about customer complaints, including information about complaint disposition. The reporting of certain customer complaint information is left up to the individual broker. The direct reporting of such information by SROs to CRD, in our opinion, would help regulators and SROs monitor questionable sales practice activities at member firms and industry-wide. In our opinion, the protection of investors and safeguarding of public confidence in the nation's securities markets is of paramount importance. We are making a number of recommendations to SEC and the Secretary of the Treasury to strengthen the detection and discipline of unscrupulous brokers. We believe SEC should implement the recommendations of its own staff study to strengthen disciplinary standards, including the imposition of a permanent bar with no opportunity for reentry when warranted. NASD is currently working on a major redesign of CRD. To enhance regulatory surveillance of unscrupulous brokers, we believe SEC should continue to monitor the redesign of CRD, and 2, require SROs to report directly all disciplinary actions, both formal and informal, and customer complaints and the disposition of these complaints. Regarding disclosure of information on customer complaints and their disposition, we believe SEC should work with NASD to develop procedures that balance regulatory surveillance and investor interests, yet protect brokers from disclosure of unsubstantiated complaints. And this is the point I want to emphasize, that we share the concerns about due process, and we are not here saying that complaint information should be disclosed to the public. What we are saying is that such information should be filed with the CRD for use by regulators. Also, we believe that Treasury and SEC should work with other financial regulators to reduce the potential for unscrupulous brokers to migrate freely from the securities industry to other segments of the financial services sector. Actions they should take include: 1, increasing disclosure of CRD information to regulators and employers in related financial services industry, and 2, determining whether legislation or additional reciprocal agreements between SEC and other financial regulators are necessary. Mr. Chairman, this concludes my prepared statement. I will be happy to answer any questions you or other members of the committee may have.
Great. Thank you, Mr. Bothwell, very much. Now we'll turn to questions from the subcommittee members, and the chair will recognize himself. Let me ask you this, Mr. Chairman. You mentioned in your opening statement that as a follow-on to the study which you did of the 9 largest firms, that now you're going to do a sweep of firms of all sizes, and that you're going to do it in coordination with other regulatory agencies. Could you give us some sense of what the plans are for that sweep and what those firms and the investing public should expect in terms of what kind of results could be produced from your study?
Well, I don't want to suggest that we're going to enter firms with armed guards and line up the brokers and search them for weapons or anything of that kind, but we're going to, together with our SROs, we're going to visit a large number of the smaller firms, the regional firms about the country, to investigate and consider what the practices are at each firm, to see whether procedures are being followed or violated, to evaluate the extent of supervision that is exercised. It would be my hope and expectation that, for instance, a manager should have some contact with the key customers of that office. That's not always a practice that's followed, but it's a good practice, and it tends to kind of weed out abuses that may develop. We're going to talk to brokers and work with compliance people and do a fairly thorough appraisal and evaluation of what those practices are in a segment of the industry that was not included in our initial sweep.
So do you have, do you have an idea as to how many firms may be targeted and what the completion date of this study might be?
My guess is that this study will probably take 8 or 9 months to complete. I'm not certain as to the specific number of firms, but when that is established, if it has not already been established, I'll get back to you with that number.
So you would report, you would give us some report back with regard to what your findings are?
Absolutely.
Okay, thank you. In the SEC's May 1994 large firm project report, the SEC staff concluded that there was no systemic rogue broker problem at the 9 brokerage firms which it had examined. That finding was based on the staff's review of hiring, retention, and supervisory procedures at the 9 firms, as well as a review of the disciplinary and customer complaint histories for the 268 registered representatives that you looked at. However, the results of the review disclosed that there were compliance problems at 25% of the branch offices reviewed, and that as a result, 40 referrals were made to the SEC Enforcement Division for possible enforcement action. What overall conclusions about the industry as a whole can you draw from the fact that the SEC found compliance problems at 25% of the 161 branch offices that you reviewed?
Well, I think that the 40 referrals of possible violations probably should be put into some perspective. I guess specifically in planning the sweep, the staff selected those branch offices most likely to have problems that were based on customer complaint information in an attempt to enforce its enforcement opportunities. While the number of referrals was disturbing, it wasn't a total surprise given the deliberately selective sample, and it wasn't indicative of a systemic problem. I might say at this point that I don't personally believe that this industry is populated with thousands of criminals and bad actors that should be placed in jail. nor do I think there are very many people walking around with halos. But I think there are clearly brokers that, lots of brokers that are playing it pretty close to the line. And I think it's in the interests of American consumers and customers to see to it that we move those brokers back a little bit from that line. So my kind of long-winded answer to your question is that we didn't find a systemic problem, and the number of referrals came from the way we selected the sample.
So what you did was you culled out initially those branch offices that potentially were going to be problems,
Yes.
and left the rest of the universe, the other 90% of the universe, alone. And then even amongst those branch offices that you did examine, you found problems only in 25% of them that were worthy of further referral over to the enforcement office.
A significant number, any number is significant, and I think we'll have a clearer picture after we complete the second sweep.
Now, what should the expectation be with regard to specific actions taken against those 40 who have been identified as problem individuals within the industry?
Well, the problems that were identified, the individuals that were identified, a number of them have been the objects of investigations and complaints and ongoing actions, and we're going to pursue that, obviously, aggressively. The results of this exercise really, if I were to capsulize what we intend to do, obviously, is to increase our examination efforts in sales practice matters. It's going to be a major focus of the Commission during coming years. We're going to see to it that firms improve their compliance capability, and I might say at this point that from my exposure to firms, I believe that they're spending more money, and this is a higher priority than it's ever been before. We're going to see to it that there is compliance with SRO reporting requirements. We're going to consider additional supervisory requirements. We're going to urge the firms to enhance their compliance and legal departments. We're going to see to it that the SROs will enhance coordinations of their own sales practice investigations, and we will adopt rules which will require disclosure of the availability of the NASD toll-free hotline so that consumers will have a better vehicle, a better way of finding out whether their broker has a clean record, and of also a better way of communicating to us what their complaint level is. We're going to try to make the Commission as consumer-oriented as possible, so we feed up from the bottom in terms of what the consumer's relation is with the firms that have practices that are not up to standard.
And will that information be made available to all consumers?
Yes.
All consumers?
Yes, we are in the process of producing brochures on different products to alert consumers in terms of what is good practice in the industry. One is already out there. We're about to produce one on mutual funds, and there'll be others as we go along.
Well, let me continue to return to the methodology of your study, which I think was quite sound. You looked at 9 firms, and then you looked at those branch offices that seemed to have indications of problems, so that you targeted those branch offices. And then you identified 40 enforcement referrals that existed amongst these 9 firms. But the interesting conclusion that I think you've come to in your study is that 88% of the 40 referrals come from only 3 of the 9 firms that you looked at. So you've further narrowed it down in terms of the firms which seem to have real supervisory problems in terms of looking at their brokers and ensuring on an ongoing basis they understand the high standards that they would have to meet in terms of their relations with customers. Do you think that the fact that such a high percentage is concentrated in only 3 firms does give strong indication of a failure to supervise within those 3 firms?
I think clearly that among those 3 firms there were procedures which should be tightened and practices which should be improved upon. I would feel more comfortable when the study is broadened in terms of citing any of the particular firms. We're certainly going to pursue practices in those firms, but I can't say to you, I can't assure you that other firms that didn't come out quite as badly in the survey may not have other problems that require the attention of the Commission. I think clearly there is a cause to go further, and we are going further, but I wouldn't isolate those 3 firms as being totally unique in terms of practices throughout the industry.
So that you, again, in summary, do you believe those 3 firms are more in need of examination and perhaps jawboning by the SEC?
Sure.
To ensure that they do upgrade
Sure.
than the others?
Yes.
Now, let's take the fact that the 9 firms are amongst the largest in the country, and in at least 3 of them, you found some serious problems with regard to their supervisory system that they have established. What does that tell us with regard to how some smaller firms in the industry might deal with these issues? In other words, since the larger firms have many more resources, are much more sophisticated than smaller and medium-sized firms, is it likely that the smaller firms will not have the systems in place to provide the kind of guidance, the kind of protections that the larger firms have been able to provide, and even there, in some instances, because of the porousness and the relative unevenness of the application of the standards which have been developed, that we've found problems with those larger firms?
Not necessarily. My experience in the industry has shown that systems can be important, and resources are obviously important. But almost unique in American industry, the commitment and the quality and the caliber of leadership that runs that firm and sets the standards will determine the nature of how the firm deals with its customers. And I know personally, having worked with the Compensation Committee and other areas in the industry recently, that some of the very best practices I have found in the leadership of some of the smaller firms, some of the regional firms. Not always so, and some small firms have horrendous practices. But I wouldn't generalize, and again, I think after the second sweep we may be in a better position to determine what the interlay is between practices in large and small firms, and what kind of resources are absolutely fundamental to doing the job that is necessary to protect American investors.
Let me ask you, Mr. Bothwell, your report, the GAO report, indicates that it is not yet possible to ascertain the full extent to which unscrupulous brokers may be active within the industry at this time. Can you explain to the subcommittee why it is difficult to identify the range of problem that does exist, the number of rogue brokers that may be out there preying upon innocent investors?
Well, Mr. Chairman, as I mentioned in my statement, the information that exists is incomplete at best, and that includes formal disciplinary actions pending and that have already been taken, but it doesn't include informal actions, warning letters that have been received by brokers for their practices, doesn't include records of compliance conferences where SROs or the SEC sat down with brokers and talked about their problems, nor does it include a centralized record of customer complaint data and how these complaints were disposed of. We think that this type of information on customer complaints and their disposition, and as well as informal actions, can serve as warning signals or red flags that the SROs and the SEC could use to identify more readily, and the firms themselves could use to identify more readily problem employees or potential employees. So the numbers that we have could in essence just be the tip of an iceberg. I'm not saying that it is, but it's conceivable that it is. And that's why we're making recommendations that all of this data be inputted into the CRD, not necessarily that it be made available to the public. We recognize that there's due process concerns and privacy concerns, but it should be, we believe, centralized and made available to regulators, not only the securities markets, but also to related markets, the futures markets, insurance markets. Insurance companies sell investment products as well as securities firms. If someone has been barred from the securities industry because they've made a misrepresentation about the risks of securities, I think it would be a very good thing for that information to be made available to state insurance commissioners, so that person couldn't freely migrate to the insurance industry and sell an annuity, which is an investment product as well. Same thing for people migrating to the banks to sell mutual funds. We believe that information should be made available to bank regulators as well. We're concerned not only with keeping bad apples out of the securities industry, but also keeping them out of the financial services sector in general.
But just to get back to the larger point which I was trying to elicit from you, Mr. Bothwell, your conclusion is that neither your study nor the SEC study at this stage is able to ascertain whether or not you have identified the iceberg of problem that exists in terms of number of brokers that may be out there, the percentage of brokers that may be out there preying upon the innocent, or you've only identified the tip of the iceberg. At this point, we don't know whether it's iceberg or tip of iceberg, and further exploration is going to be needed in order to ascertain the exact extent to which this problem does exist. Is that what you're telling the subcommittee?
Yes, as I understand, the SEC focused on the large firms because it's only the NYSE that requires its members to report customer complaint information. The other SROs do not. That, I think, is a very good step that they're taking to look at the smaller and medium-sized firms, because there have been certainly many instances in the past where very egregious problems took place in firms that were not members of the New York Stock Exchange, but were members of NASD or one of the regional exchanges. But I think the fact that the consumer complaint patterns and historical records aren't there is really a very crucial missing piece of information.
So on the one hand, we can say at this point there's no evidence that there is a systemic breakdown. But on the other hand, we can't say with absolute certainty that there aren't much more serious problems out there because of the inability to examine the data in a way that can give a comprehensive view of the industry as a whole. Is that correct? Thank you. Do you agree with that, Chairman?
I think I'd say that while evidence doesn't indicate a systemic problem, I think both the experience of this examination as well as our ongoing relationship with this industry suggests that there are areas of improvement that must be made to protect American investors. And hopefully your work in highlighting this issue will motivate the firms with perhaps some gentle guidance from the Commission to do the right thing.
Thank you. My time has expired. Let me turn and recognize again the ranking minority member, the gentleman from Texas, Mr. Fields.
Thank you, Mr. Chairman. Chairman Levitt, first of all, I want to applaud you for the way that you're discharging your responsibilities. I think you're doing a professional job in a very serious capacity. But let me go back to what the chairman was just trying to elicit, and let me underscore again: no one wants to protect a rogue broker. Someone who is acting in a fraudulent or illegal capacity, and certainly all of us are sensitive to those people who have lost money or been affected by the actions of someone of that particular nature. And also, I think that there's an admission that in this particular profession, just as you see in the legal and medical and accounting, all of the other professions, there are some problem actors. And I think, again, there's consensus that those who are problems should be dealt with severely, and that it should be a very quick action. But let me ask it another way. From your analysis, is there an epidemic of rogue brokers? Because that terminology has been used in some press reports.
In a way, I think you may have noticed in my testimony I didn't use that expression, rogue broker. I wish it hadn't been used. It wasn't our expression. It's not your expression. It was an expression created in another venue. I don't know that there are any more so-called rogue brokers than there are rogue doctors or rogue accountants or rogue anything else. But I would say that with the influx of relatively unsophisticated investors into the investment field, that the opportunities for misdeeds, compromise of integrity, zealous greed are such that I think that your work on the committee and our work at the Commission must be to raise the standards in the industry. So my answer to your question is, as I've said before, I don't think there are an alarming number of criminals out there in the securities industry. But I do believe that investor interests have got to be protected in a variety of ways, and I am dissatisfied with the general level of protection right now, and improvements have to be made. And I think that's what we're trying to get at.
And Chairman Levitt, let me hasten to say we applaud you for that effort. And if I could, I want to run through some of the points that you made regarding the 4 improvements that you would like to see. As I took those down: enforcement, information, access to information, supervision. Let me try to focus for just a moment on the second and third prong of that, the information and the access to information. And let me start by asking you exactly what you mean by the qualified immunity. As I understand that, you're talking primarily about qualified immunity when a firm files the U-5 termination report, and the prospect that there could be a defamation suit emanating from that particular report. But I wanted to ask you, what you envision by that, and can that be done by SEC regulation, or will you need some type of legislation from Congress?
Well, currently firms are required to disclose the reasons for terminating sales reps. And it's in that report that's filed with the CRD that's known as the U-5. And the issue of qualified immunity arises out of the concerns by firms and supervisory personnel about the possible liability for accurately disclosing the reasons for terminating problem sales reps. And what that means is that the firms very often are so terrified of putting down the reasons a really bad apple has been terminated, even though they should put those reasons down. They're so terrified of litigation that they don't do it. And the next employer really is blindsided by this. I guess that we believe that it would be appropriate to take steps to ensure a greater measure of candor on the part of firms and supervisors related to the reasons for terminating these reps. Now, I, again, don't believe that this U-5 should be used as a vehicle to get even with a rep who goes to another firm. That would be perfectly horrendous. But by the same token, a rep who has really abused an account, have taken advantage of an account in an outrageous way, that should be known to anybody who thinks about employing that person. I don't think we will need legislation for this, and we're considering at the Commission various ways that we can do this without going to a legislative solution to try to balance the interests of protecting the privacy and the rights of brokers with what we're trying to accomplish in terms of a greater level of disclosure. We're not there yet, but when we are, I'd like to talk to you about it. It's an issue that you're concerned with. I'd like to tell you what practice we're going to embrace and see if you agree with us that that's the way to go.
What's your timetable?
I would hope within the next several months we would come up with a program for enhancing the kind of disclosure that is available in the U-5. But before we announce anything, I will discuss it with you.
The third point that you made was access to information, centralized database. And my question would be, what would you anticipate in that centralized database, realizing that there is already a great deal of information available, but what would you envision? Who would have access to that database?
Well, I think that that database has got to be very pointed. It can't be the repository for every minute piece of information that bears upon a broker and his record. It can't be the repository for every customer complaint, which can really result in vengeful, spurious kinds of observations that pour into the database and make it absolutely trivialized and meaningless. We want to be certain that that database is very pointed in terms of displaying information about really bad performance. The NASD is working on a system in improving that database, and I guess I would say to you that the database should convey essential information without impacting the civil rights of individuals that whose names are included in that database.
Well, it seems to me that, you know, what you want to do is very important, particularly in getting to your primary objective, which you have sounded in every hearing we've had, and that's investor protection. And again, those of us on this panel want to see investors protected, want to see the investor have as much information as possible. But to me, there's a difficulty in putting in information that is necessary in determining whether someone is a fraudulent or illegal actor or someone who has had a number of disciplinary problems versus information that is in a record that is there because someone is not happy with the way an investment has turned out, perhaps due to no cause of the person who gave the advice. And to me, that's the sensitivity in which this must be approached, and I think it's a very difficult problem.
It is a difficult problem. I would say that the bulk of our effort with respect to redesigning the CRD really will give us the technical ability to search hundreds of thousands of records to identify problem brokers and target firms for examination. But we will continue to be mindful, as we have in the past, of not using this in any form of witch hunt, in any form of infringement upon the rights of brokers or anybody else in the nation, but to try to use it as a means of saying to us, Commission, we're seeing a large number of problems existing in this region or at this firm. and a lot of very serious complaints and several actions that have taken place, it's time to have a conversation with management and to see how far this goes. I think that's the legitimate way a CRD can be used, and I'm mindful of the dangers of an illegitimate way, which terrorizes brokers as a means for vengeful customers to take advantage of them. We're terribly sensitive to that, and I think we will continue to draw a balance between what we need to do our job and where we run the danger of stepping over the line and hurting the interests of firms or customers.
Thank you, Mr. Chairman.
Great. Gentlemen's time has expired, and I have a few more questions, if I may, before we move to the second panel. As you know, this is the subcommittee on telecommunications and finance. We have jurisdiction over the telecommunications industry as well. So as a result, we have a kind of a vested interest in the success of 800 number lines. And there are some problems with them, we admit, but yet in the long run, we think that it's a tremendous advantage for consumers, for our investors, to be able to get access to information by a 800 number, by some simple one-stop shopping telephone call that will avail them of the information which they need in order to ensure that they know about the history of a broker's disciplinary history. As you know, we've included in the investment advisors bill that we've passed out of the House of Representatives a provision which would establish a toll-free number to provide similar information about investment advisors. Do you agree, Mr. Chairman, that that provision is important, that it does help to ensure that investors have the information they need to protect themselves against unscrupulous individuals in the investment community?
I think it is an absolutely wonderful tool and one that we hope to promulgate. And I think a large part of that is who's on the other end of that 800 number, because as good as it is, if we don't have someone who is sensitive and capable and experienced, it can cause more problems than it can remedy. I thought you were going to ask me about cold calling, however.
Maybe we can allow you then to, if you want.
Haven't you, just as I have been the object of cold calls late at night or while you're having dinner, trying to sell you products that you didn't need in a way that you felt was really
Congratulations. I've seen that you have a new job, Mr. Markey, and you're doing a lot better than anyone ever thought you were going to do. And I am, and I'm here now to help you to manage this this windfall that you have now that you've been elected to the United States Congress. I'm kind of, in fact, shocked that someone would call me with that kind of a pitch, but they have. And over the years, and if they're doing it to me, God knows what they're doing. As the chairman of the committee with oversight over cold calls, who knows what they're doing to off of a blind list with just names on them of people who have been promoted or given a raise, and it's made public. So what can we do to protect people against that kind of intrusion upon their lives?
Well, I think this is another area that, when abused, can really cast the industry in an image which I think is destructive to investor perceptions. And our securities industry is the best and the greatest in the world because investors perceive it to be fair and open. And any of the activities which compromise that make our investors less secure and create, in my mind, a dollar and cents cost. So while I believe that cold calling is an important element used by American commerce and by brokerage firms, I feel that it has to be used in a responsible way. And the Commission staff is considering a rule to curtail abusive cold calling. Congress recently enacted the Telemarketing and Consumer Fraud and Abuse Prevention Act, and the new legislation mandates that the FTC promulgate rules regulating telemarketing within 1 year, and then requires the SEC to promulgate telemarketing rules consistent with the Act within 6 months thereafter. I think there are a number of factors which have to go into this. I think that whoever calls and tries to sell you a security or a bond should tell you at the outset what he or she is there to sell you. Furthermore, they ought to be in a position to tell you that you can hang up at any point if you feel that this is intrusive. And I think it is particularly important that anyone who tries to sell you a particular security be mindful of the Know Your Customer rule and be certain that you are an appropriate customer for that particular security. So this is the area that we're thinking about. This is what we will be talking to the industry about. You've started us down this road, and I think cold calling today is probably one of the most vexing phenomena in society, along with blowing of horns and a whole host of other annoying circumstances.
Congressman trying to shake your hand at a supermarket while you're trying to get out with the groceries 2 weeks before an election. It is an oft-noted point that as this telecommunications revolution expands, that there are tremendous benefits that are conferred upon the public, but at the same time there are a concomitant number of problems that begin to develop if those with less scrupulous motives decide that they want to misuse the technology. And that's really all we're talking about. And I want to continue to reiterate that the vast majority of all the brokers and all the people who are trying to market these products are good and decent, honest people. We're talking here about those that at the margin seek to gain a little extra advantage beyond what is ethical, beyond what is proper, and they give a bad name to everyone in the industry, and the others in the industry actually have a stake in controlling those people because the rest are playing by the rules, and the others are giving a bad name to the overwhelming majority that are trying to conduct themselves in a professional and a responsible manner. Let me just ask a couple of more questions, if I could. The regulation of broker-dealer sales practices is predicated upon a system of self-regulation, which requires all broker-dealers to belong to industry self-regulatory organizations, such as the New York Stock Exchange or the National Association of Securities Dealers. These SRO, self-regulatory organizations, are in turn subject to Securities Exchange Commission oversight. Now, prior to the GAO reports on the issue of sales practice oversight, there was disclosure that the SEC often finds sales practice violations at the firms which had been previously examined by the SROs and at which the SROs did not detect the violations which were identified by the SEC. To what extent were the compliance problems and the matters referred for enforcement described in your report previously identified by the self-regulatory organizations? In other words, how large of a gap existed as you looked at these 9 firms and then at the 40 that had problems? How large a gap existed between what the self-regulatory organizations have been doing and then what the SEC did when it went into the very same situations?
My recollection was that that gap was not significant, but to be specific, I'd like to re-examine that issue and get back to you on that. But my recollection is that the gap was not great in that I don't think it would be fair to say that a substantial number of problems were overlooked by the SROs, but I'd really like to verify that.
Okay. Perhaps, Mr. Bothwell, do you have any recollection of what the gap was that existed between what the SROs had done and then what the SEC was able to identify as a problem in each one of those branch offices?
No, we don't have any more additional information that is in the staff study. I believe something like 98 of the 268 represented had left the industry. That might have been by SRO type of action or not, but I'm not sure either.
Okay. Well, we tried to do, looking at the two reports, a little bit of analysis, and I think what we've concluded, and we'll maybe send this over to you in between the two agencies. Perhaps you can get back to us with corroboration or a further refinement of this. But we found that the SROs had identified themselves 14 of those that were later sent over to the SEC for enforcement referral, but that 26 had not previously been identified by the SROs, which creates somewhat of a gap. And perhaps, again, the SEC and the GAO, as you continue to look at this, you can help us to identify what questions are raised by the fact that the SEC's methodology in going into these firms identified 2 or 3 times the number that the SROs did that would be justified for referral and further action by the Enforcement Division. And let me go through another brief set of questions, and then we can move on to the second panel. One of the most frequent complaints that this subcommittee hears from investors is that the process of investigating and adjudicating investor complaints moves at too much of a glacial pace, allowing brokers who commit sales practice abuses to remain in the industry for many years and continue ripping off the public. On the next panel, the subcommittee will hear from 2 individuals who have gone through the process of bringing sales practice complaints against brokers. And needless to say, they are not going to be pleasant stories. In fact, for the average investor out there, they'll raise the hair on the back of their necks, wondering what will happen to them if they ever got into a situation like this with the adjudicatory process. What concerns the subcommittee about both of these cases is that it appears to have taken forever for the SROs or the SEC even to take action against the brokers in question. The New York Stock Exchange began looking into Mr. Bandick's activities, but turned the case over to the SEC in October of 1992 at the SEC's request. The SEC, however, did not file an injunction to prevent Mr. Bandick from committing further sales practice abuses and seek disgorgement of his ill-gotten gains until May of this year. With respect to Mr. Swirsky, the subcommittee understands that the New York Stock Exchange opened an investigation in October of 1991, but then dropped it when they became aware that the NASD already had a pending investigation of Swirsky's activities. And the NASD has informed the staff that it has yet to file any charges against Mr. Swirsky. Can you explain why it is that even in cases where investors win in arbitration or a substantial settlement, that there is not more prompt action by the Commission or the SROs to bring enforcement action?
I think all the commissioners are very mindful of the importance of seeing to it that these matters are disposed of as expeditiously as possible, because we recognize the potential dangers to investors. And I think the Commission is mindful of that. The staff is mindful of that. This particular case did take, these cases took longer than most. I would say to you that any firm, knowing that a broker has been accused of the kinds of problems that Bandick and Swirsky were involved with, will get rid of those brokers in their own self-interest, because to keep them at the firm jeopardizes the reputation and the image of the firm. but I think that one of the goals of the Commission is to move cases of this kind as expeditiously as possible. And I can say to you, when we have weekly meetings on enforcement matters, one of the first issues that is asked on any case that takes more than a reasonable period of time is to say to the regional office that is responsible, why has this case taken this long? We've got to do better, and I think we are doing better, but from time to time, cases for a variety of reasons will take a great deal of time. We have to be mindful of protecting the interests of people who are involved and go through a fair due process.
We are, on this subcommittee, more than any other place, mindful of the limited resources at the Securities Exchange Commission, and we are trying mightily to remedy that. And
whatever help you can get to get us our budget request approved, because by October 1st we close down unless something...
We are on a full court press to ensure that the Securities Exchange Commission is given all the resources which it has requested. And again, I appreciate how much you have to do in an expanding marketplace and how difficult it is for you to discharge all those responsibilities simultaneously with limited resources. But at the same time, the signal to the rogue brokers or others and to the investing community is that justice delayed is justice denied, and the longer it goes that any of these malefactors are brought to justice is the more likely that a wrong signal is sent to others out there that they just might be able to get away with it because the system just can't deal with them. So we want to get you the resources, and I would ask as well that you would look at a way of ensuring that the process is telescoped in terms of the time frame that these people are made accountable for any of their actions, and we would appreciate that. I don't have any other questions at this time. I don't know if the gentleman from Texas would like to be recognized again.
Thank you, Mr. Chairman. Just a real short comment involving cold calling. I guess I come at this issue from a different perspective, and I realize my perspective is not really analogous to this particular situation, but I worked my way through college and law school selling cemetery property door to door. And for anybody in this room thinking God doesn't smile on you, just think about selling cemetery property door to door, and your problems are put in perspective. I agree with you that there should be professionalism, particularly in this industry, and that vexing problems should be addressed. The calls late at night, the non-disclosure of information, someone dealing in a fraudulent or, misrepresentative manner. I don't think there's any disagreement with that. I hope that you go slow, though, and that you do not impede the entrepreneurial spirit that is out there. And I personally believe that the government can't micromanage every situation. And I do believe that there is some consumer responsibility. And I don't believe we live in a risk-free society. Having said that, I realize that this situation that you're talking about is vastly different from the one I experienced, but again, there are some analogies. And I just hope that as you proceed on this, that you will take all of these things into consideration. And I would certainly, like to be involved in this particular issue in the formation of a response as we proceed.
Let me respond to that by saying that my partners and my bosses and the people that have worked for me in my various careers have come to recognize the fact that if a potential employee came to me with a resume that said they had sold vacuum cleaners door to door, or they had cold called to sell encyclopedias, that within about 10 minutes they'd be employed. I mean,
what about cemetery property?
I love that cemetery property. Absolutely. So I think that's terribly, terribly important, and I appreciate good salesmanship. What I am talking about, however, is an abuse case. I don't think the government should micromanage it. I do believe that working with the industry, by calling attention to it, the problem will be largely solved. And again, there are very few modifications that I would call for in this regard, and I think it's the SROs working with the firms that will come up with a consensus solution, and that's the way it should go.
And Mr. Chairman, that's appreciated because it's been the experience of this member that whenever there is a problem, the Commission, the industry, in many, many instances has found, the consensus that you talked about. And I hope that in this particular instance, that's what happens. Because again, there is a recognition that there have been some abuses and that there are some problems and that those ought to be identified and fixed.
Thank you.
Thank you very much.
Great. Gentleman's time has expired. And just for the record, I worked my way through college in the ultimate cold call industry, driving an ice cream truck street to street. And while I admit that there were suitability issues raised by mothers as I was trying to interest some of my customers in some of the products that they could spend their 12 cents on, I was always able, I think, to escape. But I'm glad to know that I would have been, as I guess the gentleman from Texas would have been prime candidates for employment in the industry that you supervise.
Maybe we should ask the chairman. Chairman Levitt said that honking a horn was vexing. You didn't honk your horn, did you?
Well, to tell you the truth, if you want to hear my story quite briefly, when I arrived in Lexington, Massachusetts, the birthplace of the Revolution, they actually had a statute on the books prohibiting the selling of any victual by means of ringing a bell, and it had been on the books since 1798. I did not know that there was such a statute in the town of Lexington until the police department escorted me to the police station to explain this statute to me and to very graciously escort me to the town border. However, I had been selling in this town for the preceding month before I had been notified of this rule, and I returned the next night without ringing my bell, and the children came down to the designated place at the appointed time at each hour, and I informed them that it was my last night there and I could not sell them ice cream. The next week at the Lexington Board of Selectmen, with 30 mothers and children in the back of the room, the Board of Selectmen in 1965 voted to repeal the 1798 statute, showing that if there is, in fact, a proper organization at the grassroots, that you can, in fact, change the law. Now, interestingly, I asked my staff to go back and to check that law because I was giving a speech in Lexington about 6 weeks ago, and in 1973, 8 years after I had that statute changed when I was 18 years old, my first legislative victory when I was 18, the law was put back to 1798 in 1973, which again shows that, the price of freedom is eternal vigilance, and these children, again, continue to be deprived in this bastion of freedom, the symbol of liberty in our country. But it's for the next generation of ice cream men to battle that fight. But anyway, let me ask each of you if you would give us your 1-minute summation as to what it is that you want the subcommittee to retain as we move on to the next second panel. Mr. Bothwell.
Just very briefly, Mr. Chairman, I think that the Chairman Levitt and the SEC are taking a great amount of very good remedial actions and working with the SROs and the securities firms. I think I agree with almost everything the Chairman said this morning and what the SEC is trying to do, and with the recommendations that are contained in the SEC staff study. However, we do believe that the focus should be a little bit wider in terms of we believe steps should be taken to prevent migration of unscrupulous brokers from the securities industry to other financial services industry. We don't believe that's an issue that's had very much attention paid to it at all, and needs to be paid to it as all these separate industries come together and are essentially selling the same types of investment products. In addition, we do believe that there is a need in the update of the CRD system, which is so important and is being looked at to be a surveillance tool, to contain more information about customer complaints and the disposition of complaints. We think that that type of information doesn't have to be necessarily very detailed, but certainly summary information is starting to be collected by the NYSE for their member firms, was used by the SEC to target the branches they went to, is a valuable tool to use. And that type of information, as well as information on the informal disciplinary actions that are taken, be contained in that system as well.
Thank you, Mr. Bothwell, very much. And your conclusion, Mr. Levitt.
The markets today are so very different from what they were as recently as 5 years ago, with the proliferation of new products, new techniques, and most significantly the inflow of hundreds of thousands of new and relatively unsophisticated investors. That I think the techniques of surveillance and oversight and supervision have got to be tailored to today's circumstances, and with the dual objective of upgrading educational standards and examining and considering and highlighting good practice in the compensation field to eliminate conflicts of interest, and to see to it that we have the tools together with the SROs and the firms to root out bad practice where it exists, is a kind of ongoing program that is a continuation of the mandate of the Commission, and we intend to pursue that hopefully aggressively, creatively, and fairly.
Thank you, Mr. Chairman, very much, and we thank you, Mr. Bothwell. That will complete the first panel, and we will now move to the second panel. Would ask the witnesses to move up to the table, and we'll try to reset it for the second group of witnesses. Well, we thank each of our witnesses on the second panel for your willingness to participate in this very important hearing. And what I'd like to do is, by way of laying the foundation for what the discussion will be, is to recognize Mr. Earl Steenstra, who is an investor, who is here from Grand Rapids, Michigan, to testify as to his experience in the investment world. And what I'd like to do, Mr. Steenstra, as well as each one of the other witnesses, to ask you to keep your opening statement to no more than 5 minutes. If you can do that, you'll be very much helpful to the subcommittee, and it will also allow us to have much more detailed follow-up questions with each of you in the question and answer period. So we're going to be monitoring up here with a stopwatch your opening statements at 5 minutes. Your time will expire. So try as best you can to summarize the major points which you want the subcommittee to take from your testimony, and then we'll give you an opportunity, in the question and answer period to elaborate upon your major points. So we'll recognize you first, Mr. Steenstra, and whenever you feel ready, please begin.
Thank you very much, Mr. Chairman.
If you could please turn on your microphone. Thank you, Mr. Steenstra.
Is that a little bit better?
Thank you, sir.
Okay, thank you. Thank you very much, Mr. Chairman, and to the subcommittee members for giving me the opportunity to talk to you just a few minutes about some experiences that I have had. And I don't profess to be an expert. I certainly am not one in the field of investments. I am a consumer of my own, but I'm here primarily to represent my sister-in-law, who is now deceased. She unfortunately passed away very quickly and very suddenly, unexpectedly, about 7 weeks ago. But I think each of you probably have the documentation and basically her story and my involvement in her life over the past several years. I am also a personal representative of her estate and have been involved in a lot of her financial matters and her investments over this period of time. And so I can testify pretty well to what has gone on and I would call it the reckless abuse and mismanagement of her investment portfolio by the party that you mentioned this morning, Mr. Bandick in Grand Rapids. Nancy was about 55 years of age when she opened the account with the local investment firm in Grand Rapids, to which Mr. Bandick was the registered broker. And she received a small amount of inheritance from her mother, who had just passed away that particular year in 1986. Both she and my wife Mary shared in a little bit of an estate, and to that sum Nancy invested some monies that she had received from her late husband's estate, who had passed away a year or so before that, and started with an investment of a couple $100,000. Nancy was, as most of us are, just common folk and looking for setting up some retirement, had not had any previous investments. And Tom came along as the dealer through this large brokerage firm and set up a portfolio for her. We were there at the time. We all signed agreements with them. We had to sign an agreement for a margin account, which he said was the way that particular agency processed all their buys and sells, and categorized some of her investments to be conservative, low risk, secure, because she was looking for income rather than any risk or growth. Over the years, Mr. Bandick changed 2 different times to 3 different agencies, each time taking Nancy's account with him. And each time as he left the other agency, in retrospect, we look back, he changed the level of investment from that low risk, very conservative, secure account to more of a high risk account, and did this on his own, setting up his own documentation and moving on. We became involved with it more directly with her in 1989. She had diagnosis of some breast cancer, had surgery, was under chemotherapy and radiation therapy. And during that time, Mr. Bandick started to use the account even more extensively than he had the previous several months. And if you look in the documentation that we submitted, he far exceeded the legal definition or the court's definition of churning. The total balance eroded from that period of time, even in 9 months, from approximately $170,000 down to into the mid $80,000. He had convinced her very often about the fact that her assets were actually growing, but he neglected to tell her that her margin account, the debt, was also growing at the same time. And even though she said to stop buying, she did not give him the authority. He just kept on sending the various confirms, and until she finally couldn't take it anymore and went down to see him and said, "You got to quit." And he showed her again that the assets were still growing, but he did it for a few months, and then again he started doing it. At that time she expressed some concern, and we became involved. I think that as I listened to the dialogue this morning between the expert witnesses of the first panel and yourselves, I feel like I'm reiterating many of the things that all of you have already seen and the things of which you are aware. But, you know, that 2% of the people, or the 2% of the brokers who go into this unscrupulous areas mean an awful lot more to those maybe 2% of us investors who get touched by those people. And if in fact the $1 trillion that the chairman exhibited this morning in terms of the amounts of dollars invested in the market, 2% of that can amount to a couple $2 billion. And I think that it has become a very, very serious concern to most of us who are at that level investing. To make a long story short, in Nancy's situation is that as a matter of fact, when we determined what it was, we went to the management of the particular agency, asked for specifically what can we do to file a complaint. He indicated, well, you can do something like this. You can write to the chairman of the SEC, and they'll look at it, and that was about the basis of it. I asked particularly what kinds of systems do you have in place that would guarantee that you would give protection to your investors so this wouldn't happen again. And they said, well, we do have reports, but by the time the manager gets it, it's 2 or 3 weeks after the fact. We slapped his wrists, you know, a few months ago, and that was it until we engaged.
Mr. Steenstra, I hate to do this, but if you could just try to summarize.
Okay. I think basically there are several things that we feel are very important in this process. Some of them were touched on today in terms of the moving of people from agency to agency. There are ways, I believe, that it can be controlled and can be passed on. There's no reason for a broker like this to leave from one agency to another. I do think that there can be systems in place that the brokerage firm itself has to take leadership in protecting the consumer and not having these people on staff. There's a way of doing that, I'm convinced, of that very thing. I think the brokerage firm has to take the leadership because they are the ones out there in the community that are determining the market by their advertising, because if E.F. Hutton speaks, we all listen. Prudential is the rock. We're all bullish on the market, but they need to have that kind of leadership to make sure that they don't hire those kinds of people.
Thank you, Mr. Steenstra, very much. Our second witness is Mrs. Mary E. Murray, who is an investor. She is here from North Falmouth, Massachusetts. If you would move over the microphone, Mrs. Murray. And again, we would ask if you would limit your opening statement to 5 minutes.
Thank you, Mr. Chairman Markey and members of the subcommittee for inviting me to testify today. My name is Mary Elizabeth Murray, and I live in Falmouth, Massachusetts, on Cape Cod. Before I retired in 1984, I was a Latin and French teacher at a public high school in Framingham, Massachusetts. My husband Joseph and I had 8 children, and Joseph passed away in late 1983. Joseph had always made the investment decisions for us, and to this day, I know almost nothing about investing. Before Joseph passed away, our accounts had been handled by a broker, Gerald R. Swirsky. I believe the investments were primarily blue-chip stocks. In 1984, Mr. Swirsky transferred to Prudential Bates Securities, now known as Prudential Securities, and I opened an account with Mr. Swirsky. I have a small pension and rely on my limited capital for extra income. The new account form reflects income as my investment objective. I trusted Mr. Swirsky to handle my account and accepted every recommendation he made. I did not understand most of the activity. I closed the account in early 1990 after my tax preparer reviewed my records and said she was horrified. I had retained attorney David E. Schellenberger of Boston, Massachusetts, who filed for arbitration with the National Association of Security Dealers. A consultant, Mary E. Calhoun of Watertown, Massachusetts, analyzed the account. I lost $125,000. The average account equity was $99,554, while commissions totaled $174,730, and margin interest totaled $23,907. The annual turnover rate was 4.2%, and the account would have had to return 30.1% a year just to cover commissions and margin interest. Further, most of the investments purchased in the account were speculative or high risk. I was very successful in my arbitration, winning $419,460, including attorney's fees, opportunity cost, and punitive damages. I understand that my case was very unusual in that I was made whole. Attorney Schellenberger believes that improvements should be made to the arbitration system in order that all investors with legitimate claims may have a better chance of a fair recovery. Attorney Schellenberger, at his own expense, had the hearing record transcribed. I authorized him to send the transcript and other documents to the New York Stock Exchange for possible enforcement action. Attorney Schellenberger did so in November 1991. In March 1992, Attorney Schellenberger contacted the exchange and was informed that it had deferred its investigation to the NASD. The NASD never took any action. I understand that Prudential has settled two other claims by Mr. Swirsky's customers for respectively $50,000 and $107,500. Mr. Swirsky transferred to Tucker Anthony in November 1993 and was suspended for 2 months by the Massachusetts Division of Securities for selling before his registration with a new firm was approved by the state. In addition, Massachusetts and Florida have placed restrictions on his activities. No regulator has taken any enforcement action against Mr. Swirsky for his sales practice abuses. Attorney Schellenberger advises me he has found that, indeed, regulators only very rarely take action against broker misconduct. I am deeply concerned about this and believe that serious sales practice abuses should result in a long suspension of the broker, or better, a lifetime bar. I am concerned that many other people, including many senior citizens, are vulnerable to the predations of unethical brokers and brokerage firms. In conclusion, I believe that as a retired Latin teacher, that the law of the land should be consistent with the motto of the London Stock Exchange, dictum meum pactum, my word is my bond, rather than caveat emptor, buyer beware. Thank you.
Thank you, Mrs. Murray, very much. Our next witness is Mr. Mark Lackritz, who is the president of the Securities Industry of America. And we welcome you back, Mark, to the subcommittee. If you could move that microphone over. Thank you.
Thank you very much, Mr. Chairman. Mr. Chairman and members of the subcommittee, I'm Mark Lackritz, President of the Securities Industry Association, and I appreciate the opportunity to come here this morning and address these very important questions that are of central importance. First, how can we, the securities industry, continue to earn and maintain public trust and confidence? Are there further steps that we need to take, self-regulatory organizations or government regulators need to take, steps beyond what we're all already doing to ensure that the very high standards we have set are met by everyone in this industry? These are important questions, Mr. Chairman, because of the critical role the securities industry plays in the economic growth of this country. From 1990 through 1993, our industry raised over $4.4 trillion for job-creating, innovative, internationally competitive corporations. That's $4.4 trillion out of about a $6 trillion economy. We've raised hundreds of billions of dollars annually for cities, counties, and states to build roads and bridges, hospitals, schools, and housing. And we've increased the wealth and savings of over 50 million individuals who have invested in our capital markets. Our success is a testament to the hundreds of thousands of ethical, hardworking individuals who work in securities firms across the country, and to the millions of investors who have placed their trust and confidence in them. We know that trust is hard-earned and easily lost. In some cases, the actions of a few have been reported by the press as evidence of practices throughout the industry. However, the myth of the rogue broker, the large producer run amok, has been disproved by the facts set forth in the recent SEC report. Charges of widespread recidivists, brokers with multiple disciplinary actions continuing to stay in the business, also have been shown to be false by the report of the General Accounting Office. And we therefore welcome the opportunity to participate in your hearings, which we believe will help Congress and the public better understand our industry's record of protecting the public's trust. Our industry's #1 priority is promoting trust and confidence in our markets. As this subcommittee well knows, firms in our industry have spent millions of dollars improving compliance systems and adopting new policies and procedures to protect customers and to identify and keep bad brokers out of our business. We are highly regulated and closely supervised by the SEC, the SROs, and the states. Our record shows that the overwhelming numbers of registered representatives and their supervisors uphold the very high standards we have set for this industry. Mr. Chairman, my written testimony sets forth data on the number of arbitration claims and complaints filed against broker-dealers. In 1993, for example, the most recent year for which we have data, the ratio of arbitration claims to completed transactions was 66 ten-thousandths of 1%, an extraordinarily low number of complaints for any industry. In fact, we have set forth on the charts over there, Mr. Chairman, the record of the last 3 years mapping out the number of arbitration complaints that have been filed with all self-regulatory organizations against the number of transactions in the markets. And they show a ratio of less than 1/100th of 1% of claims filed versus transactions completed. I use these numbers, Mr. Chairman, not to minimize the problem of sales practice abuse, but to put the number of incidents in perspective. Clearly, we wish there were no complaints, or better, that no broker ever gave a customer a reason to complain. But our industry works remarkably well, and the facts prove that. We are continuing to work toward improving our systems, policies, and procedures in order to enhance against the number of transactions in the markets. And they show a ratio of less than 1/100th of 1% of claims filed versus transactions completed. I use these numbers, Mr. Chairman, not to minimize the problem of sales practice abuse, but to put the number of incidents in perspective. Clearly, we wish there were no complaints, or better, that no broker ever gave a customer a reason to complain. But our industry works remarkably well, and the facts prove that. We are continuing to work toward improving our systems, policies, and procedures in order to enhance trust and confidence in our industry. We are also working with the SEC, the SROs, and the states. For example, we are working to help implement the recommendations of the Joint Securities Industry Regulatory Council on Continuing Education to develop and implement a continuing education program for firms. Our industry is committed to ensuring that brokers are fully informed of all regulatory and ethical requirements and that they understand the products that they are selling. SIA has also created a committee which includes many of the industry's top compliance people to work with the SEC, the SROs, and the states on issues relating to the reporting and disclosure of sales practice complaints and disciplinary actions. We strongly support the NASD's efforts to modernize and rebuild the central registration depository system. And we agree with the SEC's recommendation to address the liability of broker-dealers and their associated persons with respect to state law defamation actions in connection with filings on Form U-5. Broker-dealers need immunity from lawsuits for their U-5 filings. While we believe information in the CRD, which is available to the public, should not include unsubstantiated complaints, we support the creation of a separate system by the NASD to require reporting of all complaints for regulatory purposes. We believe regulators need and should have this information about firms and individuals. In conclusion, Mr. Chairman, I want to reiterate that the success of the securities industry in playing its essential role in the country's capital formation process results from the basic integrity and honesty of the hundreds of thousands of people who work in our industry and who every day help increase the wealth and savings of millions of Americans. I want to urge the subcommittee to be careful when the press or others use terms like rogue broker or recidivists in attempts to grotesquely mischaracterize an entire industry. The facts, which this subcommittee has helped bring to light as a result of its inquiry, show that problem brokers are indeed a tiny fraction of our industry. Nonetheless, we continue to look for ways to improve upon our record. Thank you very much for inviting us to participate.
Thank you, Mr. Lackritz, very much. Our next witness is Mr. Edward Qualwasser, who is the Executive Vice President of the New York Stock Exchange. We welcome you back, Ed. Whenever you feel comfortable, please begin.
Mr. Chairman and members of the subcommittee, thank you for this opportunity to appear before the subcommittee on behalf of the exchange to discuss the presence of problem-registered representatives in the securities industry. We believe that identifying problem-registered representatives is critical to safeguarding the integrity of our markets and seek all opportunities to identify any individual who jeopardizes or threatens to erode public confidence in the markets. The large firm project, which identified certain problem situations, provided the SEC and the SROs with an opportunity for enhancing the regulatory system, and most importantly, it created an even higher industry awareness of the seriousness with which regulators view unscrupulous brokers. The SEC report on the large firm project included specific recommendations for change, and the exchange responded to those recommendations by implementing changes that we believe will enhance our regulatory program. My written testimony provides an overview of the exchange's regulatory program for monitoring sales practice activities of members and member organizations. The testimony also describes the exchange's continued commitment to identifying and prosecuting problem-registered representatives and the substantial financial, human, and technological resources allocated to the regulatory program by the exchange. I would now like to focus on the specific questions raised by the subcommittee in its August 15th letter. I do not believe that generally brokers with significant or repeated disciplinary problems are permitted to remain employed by exchange member organizations. The exchange devotes enormous amounts of time and resources to identifying and prosecuting problem-registered representatives to ensure that they are not permitted to remain employed in the securities industry. Of the exchange's 250 disciplinary proceedings concluded against current or former registered representatives since January 1992, only 21 involved individuals with any previous disciplinary history. Furthermore, during this period, nearly 50% of the sales practice cases resulted in bars or suspensions of 1 year or more. It is our experience that once an individual is barred for a period of greater than a year, that individual has a difficult time in becoming reemployed in the securities industry. I believe our regulatory program is effective in identifying problem brokers. Our systems were the basis for the data used in the large firm project for identifying problem-registered representatives, and the SEC commended them as highly effective. Our enhanced automated systems, which compile and sort customer complaint data, can identify possible problem brokers by branch or firm and follow a broker from firm to firm. Our procedures call for review of all member organization complaint reports, regardless of the size of the firm. This information then becomes a critical element of our examination risk assessment matrix, which is utilized to identify problem brokers or branches for review during on-site examinations. Our record in enforcing the exchange's rules and the Securities Exchange Act over the last 5 years shows that the exchange devotes significant resources to sales practice cases. In fact, over 85% of our caseload involves sales practice cases. Of the 595 disciplinary proceedings completed over the 3 years ended December 1993, 523 were brought against associated persons of member organizations, and 147 of those proceedings resulted in permanent bars. The exchange has not, in the last 10 years, allowed any individual which had permanently barred to become reemployed with an exchange member organization. Once a person is identified as a rule violator, swift and effective enforcement action is taken. Today, an average enforcement investigation takes approximately 11 months to complete. With regard to recommended changes as set forth in our response to the SEC on the large firm project, the exchange has made enhancements to its sales practice programs, such as increasing the number of sales practice examiners and the frequency of our sales practice examinations. In addition, the exchange has implemented the recommendation of the report to make available to the public all formal disciplinary proceedings when initiated against member organizations or registered representatives. I believe that the supervisory practices and compliance systems and controls of our member organizations have been increasingly effective in identifying problem potential problem registered representatives. Member organizations are reporting to the exchange in increasing numbers instances of potentially violative activity. This demonstrates that the actions taken by the exchange to strengthen the reporting of potentially violative activity have been successful. However, despite the effectiveness of member organizations' compliance systems and the exchange's regulatory programs, instances of sales practice misconduct will occur. Therefore, the exchange will continue to look for new ways to refine and improve our systems and procedures for detecting and deterring sales practice abuses. Thank you. I'd be happy to answer any questions. I would like to make one additional statement. You were talking about the methodology with respect to the large firm project. And in determining what instances the SROs took action against the salesman, I think you ought to look at the 90-some-odd people who are out of the business. I think a majority of those were put out by SRO enforcement actions. And so that out of the total number, I think you will find that the majority of those were found and prosecuted by the SROs.
Thank you, Mr. Qualvarsa. Our next witness is Mr. John Pinto, who is the Executive Vice President of the National Association of Securities Dealers. Welcome, Mr. Pinto. Whenever you're ready, please begin.
Thank you. Good morning, Mr. Chairman. I appreciate the opportunity to appear here before you today and other members of the subcommittee to present the NASD's views on the issues raised by problem registered representatives and the actions we have taken to address them. In general, the NASD agrees with the findings of the SEC report that problem brokers, while certainly not widespread or pervasive, are nevertheless deserving of increased attention by regulators. We also generally agree with the report's recommendations and believe that those which affect the NASD either have been or can be implemented without the need for legislative action. For 1994, as part of their regulatory plans, each of our 14 district offices was required to identify and conduct intense sales practice examinations of main offices, branch offices, and individuals associated with those offices who raise regulatory concerns due to, among other things, past misconduct relative to abusive sales and trading practices. Thus, these sales practice matters are being given the highest regulatory priority across the country by the NASD. Also, we have increased the use of decisions in arbitration cases as a source to identify problem representatives with a new formalized program which provides for regulatory referrals to our district offices for investigation and possible disciplinary action. The NASD is engaged in a multi-million-dollar redesign of the CRD system, which will be state-of-the-art and user-friendly to provide regulators with the ability to search through hundreds of thousands of records to identify and flag problem brokers and to target firms and branches for examination in a more effective way. While the CRD redesign is underway, the NASD has developed an interim automated system to identify and analyze the current registered representative population and give greater regulatory tools to focus our examinations on problem representatives and firms. New initiatives are also underway in the form of a new reporting rule to be considered by our Board of Governors next week that will require members to report the occurrence of certain specified material events and quarterly statistical data on customer complaints, again providing us with additional regulatory tools. With regard to sanctions for sales practice violations, and contrary to Mr. Schellenbach's views, the NASD has averaged close to 1,000 disciplinary actions each year. Fines have increased from $11.5 million to $44 million between 1989 and 1993, with an increase of orders of restitution, which is designed to put money back into the pockets of investors, from $1.5 million to $11 million over that same period. Through our rules, notices, publications, and educational conferences, members have been repeatedly reminded of their obligations when hiring or retaining a problem representative, and that normal supervision is not sufficient for a problem representative, which requires special supervisory practices to be tailored to address the particular problems of that individual. Briefly, with regard to the GAO report, we would certainly welcome having additional regulators directly report their disciplinary actions into CRD. Concerning the GAO's report on informal disciplinary actions and customer complaint information, I wanted to clarify comments made by Mr. Bothwell on this point, because we view this as extremely important data that is already captured in a sophisticated NASD database and used extensively for regulatory purposes. Also, customer complaint information is currently captured in CRD when it meets the reporting thresholds of Form U4. We believe this structure is appropriate and therefore support the GAO's concept that it may be necessary to maintain separate databases, one for regulatory surveillance and one for public disclosure. Because problem representatives are either barred from the securities industry, severely sanctioned, or who leave hoping to avoid its regulation can migrate to other financial services industries, the NASD is working to share NASD data with other financial services industries. We have met with banking regulators and are already providing information to state insurance commissioners on problem representatives who are also registered insurance agents. We welcome the wider use of CRD by members of related financial industries that are potential employers of problem representatives, and we are available to work with the SEC and state securities regulators in this regard. The NASD agrees with and strongly supports the SEC's recommendation that some protection is necessary to encourage firms to report accurately the reasons for an employee's termination on the Form U5 that they file with SROs. And we are concerned that a fear of litigation has reduced member candor in filing U5s. And therefore, we believe that providing limited liability protection for members will go a long way to providing more information that we could utilize for regulatory purposes. And we would also support legislation if rulemaking is determined not to be the most effective approach to devise uniform policies on liability and qualified immunity. Finally, relative to Chairman Levitt's remarks, the NASD has been a long-standing and very proactive supporter of continuing education for the securities industry, and we are anxious to work with the SEC on its tougher stance on barred individuals, which Chairman Levitt announced today. Thank you.
Thank you, Mr. Pinto, very much. And our final witness is Mr. John Perkins. He's the Commissioner of Securities for the state of Missouri. Just so people can understand, in addition to the Securities Exchange Commission and the New York Stock Exchange and the National Association of Securities Dealers, each one of the 50 states also has a securities regulator looking at the securities marketplace and offering protections to the investors within the boundaries of that state. Mr. Perkins is testifying on behalf of the securities regulators of each one of those 50 states. We welcome you before the subcommittee, sir. If you could move the microphone over, please begin.
Thank you, Mr. Chairman. Mr. Chairman and members of the committee, good morning. On behalf of the North American Securities Administrators Association, I appreciate the opportunity to appear here today. You need only to look at the members of this panel and the testimony that you've heard to the people on my left to see the problems that can result from problem brokers. The misconduct in handling these people's accounts is not an unfamiliar story to state securities regulators. Since 1978, the number of enforcement actions at the state level have increased by 40%. The number of licensing actions, those that would most be directly related to problem brokers, have increased by 20% during that time period. Unfortunately, those numbers do not tell the entire story because many of us also take informal actions of forcing brokers out of the business, forcing them to withdraw their registrations in our states on an informal basis that is not reported anywhere. For those who would suggest that this is a small problem, that it has been overblown, I would simply direct you to these individuals and to the lives that have been impacted by it. I would also say that you miss a giant point, and that is if you look only at numbers, you are missing the point. The erosion of public faith in the marketplace cannot be measured by numbers alone. This is a question not just of numbers, but of perception. What can be done about this? At the state level, many of us have taken tough actions regarding greater supervisory requirements in order to force firms to take responsibility for those problem brokers that they may employ. Other states are placing conditions on brokers' license, limiting the types of activities they can engage in, the types of products that they may sell. As I indicated before, the states have handled, I think the numbers over the last 4 years has been over 8,000 individuals or 8,000 licenses have been asked to be withdrawn at the state level so that they're no longer licensed in those states. We have also very supportive of the NASD. There's been a lot of talk here today regarding the central repository system and the update of that. States have long recognized a need for improvement in that area, and since 1992, the NASD and NASA have been in the process of upgrading that system. And I think we would probably all agree that many of the things that are suggested in the GAO report will be in that upgrade and that redesign of that system. My written testimony that you have makes several recommendations that NASA has made regarding ways to protect investors, way to head off potential scandals, and remain a high level of investor confidence in the markets. Rather than discuss all of those recommendations, I'd like to just highlight two briefly. The first is a call for the disclosure of CRD information to the public on an online database. Just as EDGAR filings have been made available through the internet, so too should CRD information. Why is this important? At the state level, we spend a great deal of time trying to convince investors to protect themselves. We have limited resources, just as all of our other enforcement colleagues have, and the only true protection can come when the investor protects themselves and by having the information available to make an informed decision. We believe that putting information regarding brokers and making that available to the individual investors is the next step in empowering those investors to make their own decisions. I would envision that in a couple of years, an individual who receives one of those cold calls will be able to go to the public library or go to their own home computer and look up not only the product that they're being sold via the EDGAR system, but would also be able to look up information about the broker, the person whose trust they are going to be relying upon in making their decisions. I think this is an essential element to ensure greater investor protection in dealing with problem brokers. The second area that I think should be explored is the imposition of a bad broker profile similar to that used by the National Futures Association. Under that program, a special internal oversight responsibilities are placed on firms that hire more than 25% of its sales force from firms that have been closed due to fraud and abuse. This model puts the burden squarely on the shoulders of those who hire problem brokers. We believe that that is where this responsibility should be, and that the greater effort should be made at supervising those individuals by the firms. Mr. Chairman, members of the committee, NASA and its members will continue to do all that we can to enforce the laws. We will try to educate the public. We hope to work cooperatively with the subcommittee, the SEC, the NASD, and other SROs, the industry, and investors to bring about needed changes in this area. Thank you.
Thank you, Mr. Perkins, very much. And now we'll turn to questions from the subcommittee members to the witnesses, and the chair will recognize himself first for a series of questions. Let me first note, if I could, that the vast majority of transactions now, in terms of volume, are institutional. That is, very large, sophisticated institutions dealing with very sophisticated products. There is much less need for protection for those institutional transactions than there is for Mrs. Murray or Mr. Steenstra, who is making a different set of decisions. That is, that they're being sold by a retail broker a particular product. This is a very good stock, Mrs. Murray. You should buy this. And here's 2 or 3 or 4 other stocks that are very good, and I guarantee you they're going to be going up in value over the next 1 year. I'm putting my own grandmother into these stocks, so I wouldn't steer you wrong. That's a different set of issues from the institutional traders who are basically dealing with very sophisticated purchases of these products on the other ends of the deal. so that when we're looking at the number of arbitration cases compared to the number of trades, it can sometimes misrepresent the overall state of the securities industry in 1994 if we don't exclude those large institutional trades where there are sophisticated purchasers and sellers for the most part on both sides of every single trade. We're concerned here with the industry the way it existed 25 years or 30 years ago and still exists in the lives of Mr. Steenstra, Mrs. Murray, and millions of others in America, where they're just transacting with an individual broker on individual stocks. Those are the problems that we're primarily focusing upon, and we think that there still are significant problems out there. As Mr. Steenstra said, 2% of the brokers misleading 2% of Americans in their purchase of stocks becomes a quite significant problem, potentially for tens of thousands or hundreds of thousands of Americans. So we're trying to find a way to ensure that the bad guys, those that have abused the process, abuse investors, are in fact disciplined in a way which makes it unlikely that they will repeat their activity, but also sends a strong message to the other 98% that they shouldn't even remotely be tempted to engage in that kind of activity, because the punishment is swift and sure for those that violate investors' trust. And I guess that's the context in which this hearing is being conducted. In a way, we not only protect, again, investors, but we protect the other 98% of the brokers who are good people, good, solid, honest men and women who are making a living trying to sell stocks to individuals, both for the benefit of the stockbroker, but also for the individuals, so their wealth will increase. So let me turn to you first, Mrs. Murray, if I could. You prevailed in your claims against Mr. Swirsky and Prudential. And the NASD, the National Association of Securities Dealers Arbitration Panel, reached a very strong conclusion that Mr. Swirsky and Prudential behaved improperly in the handling of your money. Now, in light of that, what is your reaction to the fact that there has been no subsequent enforcement action taken against Mr. Swirsky or his former supervisors at the firm, and that Mr. Swirsky is still in the securities business without any enforcement action having been taken against him to date?
I am appalled by that fact.
Expand, please.
Well, I think that a person who has a position of trust should be trustworthy, and I don't believe that he was.
Well, how confident can you be then, as you would consider making further investments in the marketplace, that the next broker you would deal with might just be another Mr. Swirsky who has never been disciplined?
Well, I don't know. I don't know the answer to that one, sir.
Would you feel confident about getting back into the marketplace?
No, I don't feel that I have enough knowledge of the market. I didn't do any of this myself. It was my husband's doing in the first place, and he had Mr. Swirsky. And I just went along with him, and I kept saying, well, whatever you say is fine. But I do want
now,
more income.
Now, are you talking to your husband or Mr. Swirsky when you say whatever you want to do?
No, Mr. Swirsky.
To Mr. Swirsky?
Yes. He did call me repeatedly and tell me what he wanted to do and explain that, yes, he realized that I wasn't getting more income now, but I would. He kept assuring me that more income would be forthcoming. It never did. It just went down.
Well, what were the words that he used to convince you that more income would come in? What would he say to you, for example?
Just that he believed a certain company, such as Data Switch, was a growing company, and that it would be producing more income for me. So I said, well, if that's what you believe, I accept it.
And you trusted him because your husband had trusted him.
Correct.
Now, how many years did this go on before you began to question whether or not your money was being properly invested, whether it was safe, whether it would be there for you in your retirement years?
Yes, it was about 5 years, sir.
About 5 years. Now, why did it take so long?
I think because, although I realized I wasn't getting the required income, I didn't know where to turn. I had trusted him. My mother, before my husband, had a broker whom she trusted and relied on his word was his bond. And I just had been misled, and I didn't know where to go. My tax preparer was the one that alerted me to the fact that something should be done.
So, even to this day, then, you feel that there hasn't been a proper set of sanctions or disincentives given to Mr. Swirsky.
I certainly do.
So if others are out there dealing with him right now, what would your Latin message to him be?
Caveat emptor.
Thank you, Mr. Murray. Let me move to you, Mr. Steenstra, just so we can flesh out your case a little bit more. You estimate that your sister-in-law lost $97,000 as the result of Mr. Bandick's activities, but I see that you ultimately settled for $47,000.
That's correct.
Not $97,000, due to concerns about arbitration costs. As I indicated earlier, it was not until May of this year that the SEC brought a complaint against Mr. Bandick. How do you feel about the fact that it took 3 years from the point at which your sister-in-law settled a complaint with Mr. Bandick for the SEC to bring charges against Mr. Bandick?
I think that that's really the key to this thing, is that if the action is much more swiftly and quicker, it's going to keep other people from hurting. I think that we were quite amazed that it was just about 3-4 months ago that an article appeared in our local paper that his license was revoked. Nancy filed a complaint and got the attorneys involved already in June of 1990. And in retrospect, we found out that he had left a trail of these kinds of things, in the whole previous 8 years that he had been in the stock brokerage business.
Meaning that there were other customers, other investors who had also been complaining about the activities of this broker and his dealing with the investors?
Correct. And what happened, obviously, is that the company that Nancy was with was also Prubesh at the time, that they immediately became involved and tried to settle, so it wouldn't go beyond their own agency. And then I find out that it wasn't until that the broker filed bankruptcy, so he would not be liable for any claims that the brokerage firm was going to lay on him. He filed bankruptcy to escape that kind of penalty, and consequently it became of notice to the state regulators.
Now, do you feel, Mr. Steenstra, having studied your own personal case and now learning a lot more about Mr. Bandick's track record and the number of complaints which had been brought against him by others as well, that his supervisors had responsibility to ensure that he was not acting in a way that would endanger the savings, the investment of people like you or any other person that was dealing with Mr. Bandick?
Very much so. I think that it's the supervisors and the individual firm's responsibility to screen out those kinds of people, to set up systems to screen it out. In Nancy's case, they noticed that
Nancy, again, being your sister-in-law.
My sister-in-law, that's correct. Her account was turned over about 2 times in the earlier few years. It went on up to past 5 times in 1 year, and the following year it was 7 times. And there ought to be a system that points up that failure on the part of the agency, I think, to screen that kind of a broker immediately.
The agency, but also the firm.
That's what I mean too.
You mean the
firm.
the firm.
Yes, the brokerage house
So
itself.
do you believe the charges should be brought against the firm itself if they knew about this and the supervisors inside of that firm allowed the activity to continue even though they knew the multiple complaints that were being brought by many investors who were dealing with the same broker?
I would think so. Personally, I feel that the firms should be fined for situations like this.
Okay, well that's helpful to us. Now let's turn to you, Mr. Pinto, if we could, so that we could deal with the issues of the adequacy of enforcement protections which are given to individual investors, the amount of information that they're given, the track records of the brokers who are problems within the industry, but potentially large generators of revenues for the firms that they are employed by. I guess that's the dilemma for a lot of these firms. On the one hand, these brokers may be crossing the line and endangering the savings and investments of individuals, but on the other hand, for a supervisor, as they look at this individual, well, my goodness, they're bringing a lot of revenue into our firm. Look at all the commissions that we have. Look how much money it means to our firm. So there's a tension that exists. The supervisors in the firm and the NASD, or the New York Stock Exchange, as it looks at the individual and the firm, have to make some tough calls. It seems to me, in listening to the two previous cases, that they're pretty clear cases, that there should have been at least an additional step in each case that was taken to further foreclose the likelihood that there would be a repetition. So why hasn't the NASD, Mr. Pinto, filed actions against Mr. Swirsky in light of the findings of the NASD arbitrators in Mrs. Murray's arbitration case, that there was a reckless disregard of the claimant's rights and open-eyed reckless disregard for the claimant's monies, in the words of the NASD arbitrator himself?
Well, let me first address your opening comments. I don't know that either of these individuals was related to be the large producers in the firms. I think the study that was done on the joint investigations with the NASD, New York Stock Exchange, and us showed that, in fact, there was no correlation between large producers and reps that get customer complaints. With regard to specifically the situation that Mrs. Murray referenced, certainly I can understand her concerns and frustrations. I'm delighted that the NASD arbitration decision provided her with full restitution of her monies. I can say Chairman Levitt, in responding to a similar question earlier, said, and I would concur, that there are times that some investigations take longer than you'd like them to take. In this particular instance, I looked into this, and there's a little dispute as to when the investigation was initiated, but according to our records, we began reviewing it in '92 as a result of a termination for cause. And you have to understand, as we do an investigation, we do not only go in and examine the one complaint for a particular customer. We will go in and conduct an investigation. We'll expand that investigation to encompass other accounts of the particular representative. If it appears that it's more pervasive than an individual, we'll go beyond and obviously look at the activity of the branch or the office. And we always include a review for supervision. In this particular case, there were over a dozen accounts that we reviewed. And once that matter was completed, as Mrs. Murray referenced, the transfer by Mr. Swirsky to another firm, we conducted a review of activities of Mr. Swirsky at the other firm and looked at in excess of 50 of his accounts to ensure that what had transpired, or what we believed had transpired at his other firm, hadn't carried over to the new employer. Did it take longer than I would like? Certainly. And in looking at where we are today, the matter is completed as far as the investigation. There's been a preliminary review by our Business Conduct Committee. And while I'm not in a position as a staff member to say what will emanate from the committee's review, based on what we see as a result of the review, which appears to be unsuitable activity relative to the investment objectives and the way the account was handled, I would anticipate that a formal disciplinary action will be filed against Mr. Swirsky, and I also anticipate, having reviewed the information, that there is a strong likelihood that there will be a disciplinary action involving the failure to supervise on the part of that particular office.
So the issue then, Mr. Pinto, is this. I don't want to determine who should be judged innocent, guilty, who should be sanctioned or not sanctioned. My concern is that Mrs. Murray's harm occurred 4 years ago in terms of the resolution of her case. There's an individual that had comments, and a firm that had comments made about it by the NASD arbitrators that contended that the claimant's rights had an open-eyed, reckless disregard for their interests, that prudential supervision of Mr. Swirsky was nearly absent, that the firm was interested primarily in the substantial fees produced by respondent Swirsky in this account. All of these conclusions 4 years ago by the NASD. And we just, I guess, get back to the question of justice delayed being justice denied, both for Mrs. Murray and for Mr. Swirsky. It hangs out there for 4 years as a cloud over him as well, without some kind of final resolution. But from Mrs. Murray's perspective, she's saying caveat emptor for 4 years to all of those that may be dealing with him, because there has not been a final resolution of this issue in terms of how the NASD wants to restrict or limit him in light of what happened in Mrs. Murray's case. And that's the dilemma. I don't know how you should finally resolve it. I don't want to recommend how you should finally resolve it. But I do think it should have been resolved long ago, if only for the closure of an issue which cast a light upon the integrity of the marketplace. So in light of the recommendations which you're considering in terms of reform of your procedures at NASD, could you tell the subcommittee what you would give us as assurances in terms of future handling of cases like Mrs. Murray, in terms of a swift dispatch of them, regardless of what the final disposition may be?
Well, and as I said at the outset, not to repeat it, I certainly would have liked to have seen this case move along a lot more rapidly than it has. As you are well aware, there's a large step between allegations and being able to substantiate those in a disciplinary proceeding, where you need to be able to have documentation and evidence of the violations. I think one of the things that's been a tremendous enhancement is something that I mentioned in my remarks and is covered in more detail in the written testimony, is the fact that we've greatly enhanced the coordination between our arbitration department and arbitration decisions that emanate and the regulatory aspects of the NASD. Both through better coordination and more particularly with changes in our rules, which were recently approved by the SEC, clearly provides the capability of our arbitration panelists to make referrals for regulatory investigation once a decision or a settlement has been finalized in an arbitration case, and also reiterated the authority of the arbitration staff to make referrals to the NASD regulatory staff at any point in time during an arbitration. So I think I've always viewed the arbitration decisions as an area that could greatly enhance the regulatory data that we utilize in focusing our regulatory efforts. So I think that's a major improvement.
The point I'm trying to arrive at here is that we're not 4 years from the point at which Mrs. Murray made an allegation. We're 4 years from the point at which the NASD arbitration panel made a decision with regard to the conduct in question. And I think I would distinguish that from being an allegation, which is what Mrs. Murray does, to something which is far more conclusive on that individual issue, although not conclusory with regard to what should happen to the individual broker subsequent to that case, beyond the monetary reimbursement to Mrs. Murray. And I think that's the problem. There is essentially already a process in place at NASD that has led nowhere over the 4-year period thus far that has transpired since the decision. And that's what is of concern to us, because the other investors in the marketplace are still dealing with him without having the knowledge now that Mrs. Murray has about a conclusion which has been reached by the NASD about him, preliminarily, we'll say, in an individual case, but perhaps more tightly reining in his activities in general subsequent to a further reevaluation. So that's the dilemma I had. Let me move on, Mr. Pinto. On page 11 of your prepared testimony, you indicate that in 1993 you changed your rules to permit an arbitrator, once a case is settled or an award is rendered, to initiate a referral to regulation for possible violations of NASD rules or the federal securities laws. Does that mean that arbitrators are required to make such a referral in cases such as Mrs. Murray's, where the decision has been in favor of the investor, or does the arbitrator have full discretion whether or not to make a referral?
Since the time of Mrs. Murray's case, there's been a number of initiatives with regard to the arbitration process and how it interrelates with regulation. One of the things that's been lacking or not as emphasized as it has in the recent past over the last year or so is in the area of arbitration education of the arbitrators themselves, to make them clearly aware of their responsibilities if, in fact, during the arbitration process they hear about conduct that they believe is violative of NASD rules. And now there is a statement that is read prior to each arbitration hearing to make arbitrators aware of that responsibility. At the end of the arbitration hearing, they are questioned by the arbitration staff to determine whether any issues came up during the arbitration that seemed to require referral to a regulatory arm of the NASD. So yes, I think the panelists that are hearing the arbitration cases today are far more attuned to their responsibility. I don't say it's discretion, it's a responsibility that we're telling them that they have to make referrals for regulatory follow-up and potential disciplinary.
Okay, but just so I can more closely define what the discretionary powers of the arbitrator or the staff working on a particular arbitration may be. You're saying that in Mrs. Murray's case, when an NASD arbitration panel rules in her favor, that it is still, even after your 1993 regulations or processes have been put on the books, it is still within the discretion of the arbitrator who made the decision in Mrs. Murray's case as to whether or not there should be a forwarding of the case onto an enforcement wing of the NASD. So that as they're evaluating the sensitivity of the broker at that time, their evaluation of his or her reaction to the situation, they can determine whether or not they need to take further action, or they can recommend what counseling or re-education. I mean, what is the substitute, in other words, for a referral to enforcement?
Chairman Markey, there's a decision. Someone has to make a decision. They're reviewing the facts of each arbitration. Not every one of the arbitration cases involve violations of securities rules. And when they're hearing the facts that are developed, they're reviewing whatever information has been submitted by the parties that are subject to the arbitration, they make a decision based on what they're hearing about whether there seems to be conduct that violates securities laws.
So you're saying, in Mrs. Murray's case, was there a violation of securities laws?
Well, based on the review that was done subsequently, in my view, yes.
Yes.
And, if I could finish, if at the time we had the same process in place that we have now, that referral would have been made. I am very confident of that because the facts of the case seem to be fairly straightforward. We would have gotten the referral sooner in the process than perhaps we were brought into the investigation without that coordination between arbitration and regulation. So the decision has to be made by the arbitration panelists about whether there's a reason to make a referral. They do 5,000 cases a year, and not all of them rise to the level of...
But do you believe that there should be an automatic referral if there is a violation of securities laws? or an SRO rule. A violation of an SRO rule, a violation of securities laws, should there not be an automatic referral? Now, I'm not saying that at the enforcement level that they have to take action, but at least to review it in order to make sure that there has been a full discussion of the issues that are raised by a decision based upon a securities law violation.
In concept, that's the purpose behind the
I appreciate
arrangement
that. Give me an example then of where you think there might be a securities law violation or an NASD rule violation where there shouldn't be a referral, where there shouldn't be a follow-up examination.
I'm not certain that there would be very many situations. There may be some situations, Chairman Markey, where the substance of the arbitration award has nothing to do with the regulatory side, and there might have been some infractions, some technical infractions, minor rule violations that were not serious or substantive, where perhaps the need to take regulatory action is not there. But where there is a violation, where the substance of the arbitration proceeding involves sales practice type situations, suitability, unauthorized trading, conversions, any of the serious sales practice abuses that we're talking about here today, I can't think of any instance where I would not want to have a regulatory referral to follow up.
That's very helpful to us. My time has expired. Let me turn and recognize the gentleman from Texas.
Thank you, Mr. Chairman. I'm going to be fairly brief. I have to catch a plane back to Houston. But let me ask you, Mr. Lackritz, Mr. Pinto, Mr. Quarwasser, even those studies have found in the worst case scenario that 2% of the brokers have had a single disciplinary action. I know that none of you want an association with a broker-dealer that has had the effect on people like, obviously, the person who had an effect on Ms. Murray and Mr. Steenstra's sister-in-law. But as I understand, each of you have addressed the problem within your own system, and that you are enhancing your system to ferret out and discipline in a quick manner those who have broken the laws or who have dealt unfairly or in a fraudulent manner. And what I was going to ask you is just very briefly, could you summarize the enhancements that you're making to your system to address this particular problem?
Sure. Thank you for the opportunity to describe that. First of all, let me just begin with the premise. We don't want bad brokers in the securities industry. It's not in our interest. It's not in the consumer's interest. It's not in the public interest. So we share with the subcommittee, the self-regulators, and the SEC the desire to rid our industry as completely as we possibly can of any bad brokers. I think it's important to keep the problem in perspective, though, and I think that's why the numbers and the data help to do that in terms of identifying what I think is a fairly tiny fraction. But we're trying to do better and keep even that tiny fraction down. First, we're investing millions of dollars in enhanced compliance systems and supervisory systems in the firms. A number of the firms have already invested literally millions of dollars. In terms of training new brokers, one of our firms spends $50,000 to train every new broker that's been brought in. Another firm just reported that they spent $40 million to train 1,200 new brokers that have been brought in. In addition to that training, we now have a mandatory continuing education requirement that's going into effect over the course of the next year that has both a regulatory component and a firm component. And in that, it requires every professional in the business to get that kind of training and continuing education to keep current with regulatory developments and to keep current with new developments with respect to products and services. Moreover, there are improvements that can be made with respect to reporting and disclosure of information, which I've outlined in a little bit more detail in my written testimony, but involve helping to rebuild and improve the central registration depository. We support the new effort by the NASD to set in motion a system like the Rule 351 system that the New York Stock Exchange has in place for reporting of all customer complaints, and an effort to basically make more of that material and more of that information available to regulators to improve their examination process and to improve their audit process. Now, have we got a perfect system? No, obviously we don't have a perfect system, and the evidence of that are the individuals that are testifying here today and the other cases that are out there. But are we doing it? We think we're doing a good job. We're trying to do a better job, and we're trying to improve the performance that we've had so far.
Thank you. I think some of the areas that Mr. Lackritz mentioned. Certainly the continuing education, where the NESD has been very proactive over the years in trying to develop ongoing education for the securities industry is important. I think one of the major things that's extremely valuable in this whole process has been mentioned many, many times, but it can't be overemphasized, and that is the complete redesign of the CRD system. The criticism of the system is from the point of view of what it was originally designed to do, and that was just a registration system. It does what it was designed to do. However, the needs that we have for the information in there have far outgrown the system. We are redesigning it so that it will become a very active surveillance and regulatory tool for members and for regulators to use, not only in being able to more timely identify problem reps, firms, branches, but to be able to focus the investigative efforts that we have and be able to target those firms and be able to address issues a lot sooner in the investigative process than we are today. And we are also looking, Mark mentioned the Rule 351. We think that's going to be a valuable tool where we'll be getting material event reporting as well as customer complaint statistics under this new rule that we'll be going to our board with. And I think we're also making a major initiative to see how we can better utilize technology in order to help us do a more effective examination as we go and conduct field inspections of our members.
I'd like to start off by saying that sales practices are not new to the New York Stock Exchange. And it's not since May of 1994 that the exchange has started to implement the process of examining for abusive sales practices. And in fact, if you look at the SEC's report, most of the recommendations are that other SROs conform to rules which the exchange has had for several years. That being said, we do think that it's important to continue to upgrade our systems and our rules. We've added additional sales practice examiners. We've increased the number of examinations that we do in the sales practice area. We continue to spend substantial resources in upgrading automation of those areas. We've determined not only to look at all complaints, but we've given them a weighting so that when any salesperson complaints reaches a certain weighting, so that we don't say all complaints are the same, but when serious complaints come in, we will go out and do an immediate examination of that person rather than wait till he comes up in our examination process. I might also say that the 2% number that's been giving out and that was in the GAO report, I think had the GAO's eye on the wrong ball. We're not really interested, at least the New York Stock Exchange and I, are not really interested in people who have had disciplinary incidents in the past and are no longer violating customers' rights. We're interested in salespeople who are abusing customers today, whether they had any prior disciplinary history or not. The point of all of our sales practice, whether examinations, whether it's the firm's compliance procedures or the SRO's oversight, should be to prevent salespeople from abusing customers. And we think that that's what we do, and that's where we ought to keep all of our resources.
Mr. Perkins made the point that even though the statistical evidence shows that we're talking about a small percentage of broker-dealers, even that small percentage does affect the credibility and affect the overall image of the industry. And I know you, or I would assume you agree with that point. Chairman Levitt came before us earlier and talked about what his vision is and what he would like to accomplish in increasing the investor protection. And he talked about enforcement, information, access to information, and then supervision. And it seems to me that when you talk about enforcement and you talk about supervision, you basically get to the point of needing good information, and then you get to the question of who has access to that information. And the question I wanted to ask you was in regard to information, and particularly in regard to the CRD. And Mr. Pinto, you said just a moment ago that there needs to be a complete redesign of the CRD. And if I remember what you said earlier in your testimony, and the same to you, Mr. Lackritz, you actually talked about a bifurcated system where you would have one stream of information going to regulators and one stream of information going to the investing public. And I was going to ask you to expound on that if you could, and if you could add to that how that is affected by the open records statutes of various states. And Mr. Perkins, I might ask you to join in after they've, responded to that point.
Well, with respect to the information that goes into that system, because it has to be made available to the public, we think that the only information that should be in the system that's available to the public are completed disciplinary actions or resolved complaints, not mere allegations. If you make all the allegations that go into the system available on a broad basis, then you run the risk of really hurting and destroying the reputation of lots of people, in fact, who have not been found to have done anything wrong. So we think it's very important, but nevertheless, that kind of customer complaint information ought to be available to regulators, so they, in fact, have adequate use of that information for targeting investigations and targeting examinations. But we would strongly oppose making mere complaints available to the public as opposed to completed actions.
Let me just ask you to also respond to the open records part of that, if that is made available to a regulator, as I understand the open record statutes of some states, if it's made available to Mr. Perkins, that in essence is going to be made available to the public, and consequently, does that need to be dealt with by the SEC, or would it take some type of federal preemption coming from a statute?
I suspect it would take federal preemption coming from the statute, or the states would, either the states would have to deal with it specifically and adjust those open record statutes, or it would require some preemptive legislative action.
Yeah, I'm not certain about the state laws as to whether the open records and public disclosure requirements would pertain to information that's obtained for purely regulatory purposes from a separate database in the same vein as it would in a system that they are actively participating. I mean, that's something that we'd certainly have to look into, because there's no question about the importance of the data. That was the point I was trying to make. It's very important information. Whether these are unsubstantiated or undocumented claims where it might not be in the issue of due process or fair to publicly disclose all of this information, it certainly is valuable regulatory data that we need to see as we look to where to target our resources and to have a feel for, what particular branches or firms or reps are getting a preponderance of customer complaints. You have to put it in perspective. We probably average about 4,000 customer complaints a year, and we get about 3,500 or so terminations for cause. And I know the New York Stock Exchange gets a large number, so there's a lot of data that's coming in, and you really need to be able to take that, use it in the most effective way to help fine-tune your surveillance and regulatory programs, but to publicly disseminate every one of those unsubstantiated customer complaints, I don't see helping disclosure, and I don't see it fitting with issues dealing with due process and privacy, and I certainly don't see it improving the regulatory process.
When you start dealing with this issue of disclosure of information, I have, since the days that I was the chairman of the CRD committee in NASA, have urged a format be adopted on CRD to inform people as to what this information means. I mean, anyone who has looked at the CRD system at the present time sees a hodgepodge of information. The redesign will go a long ways towards trying to address those types of concerns. This is extremely important information. It's important from a regulatory standpoint, certainly. I mean, we take action based upon those types of filings. Somehow or another, we have to together arrive at a solution, however, that deals with the problems that these individuals have. Because if we create a bifurcated system, my question to you is, how soon will it be when one of these people have a problem? And I was asked, I mean, we encourage, one of the things, we've got a toll-free number at the NASD. We're trying to get greater consumer responsibility, I think was the phraseology you used regarding this. Consumer responsibility to check out these types of offerings, to check out the people who they're dealing with. What happens when Mrs. Murray calls my office and says, I'd like to check out Mr. Perkins, and I go to the CRD system or the public, whatever the public area is, and I say, well, Mrs. Murray, I don't have any information. There's no complaints here. But I know in my database over here, there are 15 customer complaints pending against this person that she's dealing with. My question is, how long will it be before I'm back in front of you or back in front of my legislature in my state asking me, Mr. Perkins, why did you let Miss Murray get ripped off by somebody who you knew had 15 customer complaints? That's the problem. Somewhere you have to draw some lines. And I agree with Mark that it's the unsubstantiated single complaint, you don't want that being made public. However, at some point in time, you need to be able to tell the public that, yes, this person is a problem. I mean, we've gone through a long discussion here of how long it took for there to be regulatory action regarding their complaints. What was supposed to be done during that time period? During that time period, if you call the NASD and were only given actions that had been completed, you would never have known that all those complaints existed. It would never have come to light. Somehow we have to try to arrive at some happy medium in there in which we deal with the public's right to know. We base our whole system upon full disclosure. I mean, the person who sells a security to a firm that is selling security, I mean a company whose securities are being sold, has to disclose all sorts of information in a prospectus. They have to disclose things like whether the president of the company may have a heart condition if they are a key player in the company's history. That's clearly a very detailed type of information. Yeah. That is the basis for our whole system, is disclosure.
Let me just say very quickly, and as a layman, I don't think I can sit up here and tell you what necessarily should be disclosed or not disclosed. I feel like Chairman Levitt and Chairman Markey, and I think the panel that is before us, that the more information, good information that the public has, the better off the system is, the better off the investing public is. But it seems to me that there's a distinction between a unsubstantiated allegation in something that has been initiated as an adjudicatory proceeding. I see a distinction there, and I would hope that reasonable minds could get together and come up with a response that gives the regulators and the investing public the best possible information. And I'm going to ask one last question. I'm going to have to run to catch that plane. Chairman Levitt also talked about a specific thing when he talked about information. He talked about the concept of qualified immunity in that dismissal form. Just very quickly, do you think that helps or hurts? Your quick response, Ms. Lackritz.
That would help considerably. We think that there ought to be full immunity for disclosures made on U5 broker termination forms in order to encourage firms to be as forthcoming as possible and to get as full information as possible to the self-regulatory organizations and the public. Because of the pending threat of litigation, defamation suits and that sort of thing exercises sort of a chilling effect on that information. And in order to encourage the full disclosure, we think immunity is appropriate. Qualified immunity goes part of the way, but we would favor full immunity.
Would the gentleman yield just briefly, just so that we can put on the record, is there any evidence of any successful suit ever having been brought because of a statement, a truthful statement made by a securities firm with regard to the conditions surrounding the dismissal of a broker?
Yes, there have been a number of them, and I will endeavor to get the details of those. And
could you provide those for
Absolutely.
the record? I think that would be helpful for us to examine. Thank you. I thank the gentleman.
Mr. Pinto, did you want to?
Well, just very briefly, we think that qualified immunity is an essential, critical action that's necessary, and support it either through SEC rulemaking or legislation. I think it's a very, very important issue.
We agree, and I would echo what John said.
Mr. Chairman, thank you very much.
I thank the gentleman, and we'll, at this point, bring the hearing to a conclusion. I'd like to say that I think that both Mr. Fields and I and the other subcommittee members are very pleased to hear about the new initiatives at the regulatory level, both the New York Stock Exchange and NASD, and at the SEC level. Each I think helps to build more confidence that there are changes in the wind that can give more protection to investors. It's very important that there is improved compliance, that there are more protections to curb abusive sales practices, and to strengthen enforcement. We want to continue to work with the SROs, with the SEC, and with the securities industry at large, and the state regulators to guarantee that there is a set of safeguards that are built in to give immediate protection for the potential victim as the broker moves in on them, but to also give warning to subsequent investors after some decision has been made with regard to a violation of a confidence, a trust, or a securities law itself. And I don't think we've quite arrived at that point yet where there is a full, speedy transmission of that information into the hands of unwary investors, but I think we're making some real steps towards effectuating that end. I want to thank you, Mrs. Murray, you, Mr. Steenstra. I know it's a sometimes a difficult thing to come forward and to tell your own story, but you're helping the subcommittee, and I think helping all others to understand the problem and to bring some real solutions to the case that can't ever bring you back and make you whole again, because we can't relive the past, but I think we can help to protect thousands of others in the future to make sure that they're not victimized the way you were. So we thank each of the witnesses for their testimony, and with that, this hearing is concluded.